Thank you, Worship. The court pleases 23rd day of May 2023. State court case number 20-113/2023. State against Senowe Ishmael Matswara and others. Is a partly had bail application. Presiding Judicial Officer, Mr. M. Khabisi, for the state SS Matuku. The court Prita, Mr. Manyosi, and applicant 1 and 4 are represented by Mr. Mururi. Accused applicant number 2 is represented by Mr. Makamedi. Applicant number 3 is represented by Mr. Kwenani. Applicant number 5 is represented by Mr. Buota. And I suppose we are all ready, Worship. Thank you.
So, please, Your Worship, I confirm my appearance on behalf of the first and fourth applicant. I do confirm that I'm in a position to proceed with arguments today. So, please.
Thank you, Worship. Your Worship, I confirm my appearance on behalf of the second applicant in this matter, and I confirm that we are ready to proceed with arguments.
May it please the court, Your Worship. Indeed, we are ready to proceed. Masido Kwenan representing accused number 6 in this matter.
As it please the court, Your Worship, I confirm my appearance on behalf of applicant number 5. I confirm I'm ready to proceed. I just had a flu, but if I address the court and the court can't hear me clearly, the court just have to indicate to me, but I'm ready to proceed, Your Worship. As it please the court.
Mr. Court, please, Your Worship. Mr. Court, please, Your Worship, as indicated, today is the day that was set aside by this court for arguments in this bail application. And I proceed to, firstly, with your leave, Your Worship, launch and address this honorable court in as far as accused number or applicant number 1 is concerned, and thereafter will address the court in as far as applicant number 4 is concerned with your leave, Your Worship. Because I, as the court will note, that the arguments will more or less be similar. This is an opposed Schedule 5 bail application. And the state in this matter prefers a total of 13 charges against the applicant. The applicant's affidavit is before this honorable court. And I will not, Your Worship, go into much detail in as far as that is concerned. It is before the court. The affidavit is commissioned and was signed on the 11th of May. The respondent opted to lead oral evidence, and this was through the evidence of one Lieutenant Colonel Flyman. He addressed, or rather his testimony was threefold. It addressed the personal circumstances of each of the applicants. It set out how each of the applicants is allegedly linked to the offenses and the reasons for opposing the bail application. The applicant, and this is applicant number 1, was arrested on the 4th of April. He has been in custody for a period of 1 month and 14 days. The investigating officer has indicated in his testimony that it will take approximately a month or 2 months for the investigations to be finalized. It must be noted, Your Worship, that this on its own would mean that the applicant would need to spend over 3 months whilst simply awaiting for investigations to be completed. And I respectfully submit that that would not be in the interest of justice. The investigating officer confirmed and corroborated the personal details of the applicant, save for certain aspects where his investigations did not lead him. It became apparent when the investigating officer was testifying that his opposition of this bail is threefold. That there's a likelihood that the applicant may interfere with the investigations, that there's a likelihood that the applicant will undermine the justice system, and that there's a likelihood that the release of the applicant on bail would disturb public order. And I pause here, Your Worship, to refer this honorable court to the matter of S versus Joan, The 1973 matter, open bracket 1, SA 842 C, particularly at paragraph on page 852, paragraph C, where the court held that, and this is my own translation, Your Worship, the matter is in Afrikaans. The court held that the investigating officer's view in bail proceedings is not the only view that must be considered, nor is it the most important one that should be weighed with a court as to whether or not bail should be granted. The legal principles, Your Worship, close quote, the legal principles and the application to the facts. It is tried that Section 60 of the Criminal Procedure Act is applicable herein. And furthermore, that the Constitution of the Republic guarantees certain rights to individuals. And I wish to refer this Honorable Court particularly to Section 35(1)(f) that guarantees a right to be released from detention if the interest of justice permits, subject to reasonable conditions. And Section 35(3)(h), which is the right to be presumed innocent. The right to be presumed innocent is very important, Your Worship, because for as long as one is yet to be found guilty by a court of law, that right stands. And in this regard, I refer this Honorable Court to the matter of S versus Duplessis and another, 1993, open bracket 2, close bracket, SASV 379, open bracket T, close bracket, at 394, H to I.
Sorry to interject. Will you repeat the citation?
The citation 1993, open bracket 2, SA SV 379, open bracket T, the Transvaal decision, close bracket, at 394. And in particular, paragraph H to I. And once more, this is one of those matters which were penned in Afrikaans, but I will, as best as I can, translate it to English, Your Worship. The test for a bail application, and I quote, the test for a bail application is that it must be granted if the administration of justice will not be harmed by it. This has been said as far back as R versus McCarthy, 1906, TS 657 at 659. The basis of this rule is that it is presumed that an accused is innocent and that it is unfair that an innocent person remain in custody. The most important questions that need to be answered are: will the accused attend his trial? Will the accused prejudice the administration of justice by interfering with witnesses or obstructing the police investigations? And that has been as far back as been prior to the current constitutional dispensation. Your Worship, the interest of justice, this court will well be aware that it is set out, certain grounds thereof are set out in section 60, 4, A to E. And I will not read those into the record, Your Worship. I accept that it is common cause. But prior to delving into the provisions of section 64, it is important to state that the Constitutional Court in S versus Dlamini, S versus Gladla and another, S versus Hubert, and S versus Skitekat. And I'll refer to this matter henceforth as S versus Dlamini. And the citation in as far as that is concerned, Your Worship, is 1999, open bracket 4, close bracket, SA 623. And it's a Constitutional Court judgment. It is aptly stated that the interest of justice must be primarily, and I quote, primarily on that you said paragraph 52, Your Worship, primarily on securing the attendance of the accused at trial and on preventing the accused from interfering with the proper investigation and prosecution in the case. Grichla J, in paragraph 52, correctly holds that the notion of likelihood means that there must be a possibility that such risk will materialize. He in fact says, that is in paragraph 52, Your Worship, a possibility or a suspicion will not suffice. It is therefore important to note that the word likelihood in this context entails a probability, and that would be the context as set out in section 60, subparagraph 4, subparagraph A to E. That the word likelihood in that context entails a probability. Assumptions, speculation, and guesswork clearly does not rise to the standard. I turn now to deal with the provisions of section 64A. It is common cause that the applicant does not have any previous convictions, nor does he have any pending cases, save for the current one. The respondent did not adduce any evidence to suggest that the applicant is prone to violence or that he will in any way commit a Schedule 1 offense or any other offense for that matter. This Honorable Court is referred to paragraph 37 of Exhibit A1. It is therefore submitted that the applicant will not endanger the public, nor will he commit a Schedule 1 offense or any other offense if released on bail. And as far as section 64B is concerned, the applicant is a South African citizen by birth. He holds a South African passport. He has a fixed address, and he even has an alternative address, being that of his sister. The investigating officer meticulously confirmed that he also knows the parental home of accused number 1 to be Kutuanong in Orendalsres. But of particular importance, Your Worship, is that at his arrest, the applicant handed over his passport. He did not try in any way to mislead that he doesn't have a passport. In fact, the investigating officer says he cooperated with my investigation. And I pause here perhaps to address the issue where an impression was created that the applicant has been traveling to Lesotho to and fro. But this court knows that initially we were told that it was 8 times. It became clear it was only 4 times that the applicant went to Lesotho. And even then, that is no indication that one would flee, particularly given that they have handed in their passport. I therefore submit, and respectfully so, Your Worship, that the applicant is not a flight risk. Your Worship, the investigating officer, that is in terms of section 64C, stated that he was afraid that if admitted on bail, the applicant would influence or intimidate witnesses. And this, Your Worship, was premised firstly on the incorrect assumption that the applicant had access to personnel records and therefore he would know the addresses of would-be witnesses. And this would be the witnesses that had testified, according to the investigating officer, that had testified against the applicant in his disciplinary hearing. And he correctly considered, that is the investigating officer, under cross-examination, that none of the witnesses which he believes will come and testify in the trial indicated to him that they were threatened or interfered with in any way, and therefore I respectfully submit that this fear by the investigating officer is ill-founded. But of particular importance is that the second leg was, he was the supervisor of these witnesses, that is applicant number 1 now. Your Worship, I wish to refer this Honorable Court to a beautifully written judgment by the Khodi J, as he then was, in the matter of Rodney Kenneth Landela and another versus the state. And the citation I have for it is S open bracket, A04, stroke 2017, close bracket, open bracket 2017, close bracket, ZAGP PHC 745. Now I wish to quote him in paragraph 24. And he says, the investigating officer in his evidence during the bail application touched on the possible intimidation of the witnesses, also seen in light of the fact that the accused one, for example, was a senior ranger in the park, and that the state witnesses were his juniors, and therefore suggesting that he can easily influence or intimidate them. I do not think that there's any basis for this contention. Firstly, it is clear from the record that both the accused were dealt with as being automatically suspended from their respective employments by virtue of the allegations made against them. Once accused one, for example, is out of the park, the chances of intimidation and interference with state witnesses, his juniors, would fade. And I submit that this is exactly what has happened here. In fact, Lukhodi J was dealing with an aspect where a suspension was in contention. In this matter, we know for a fact that the applicant has not been suspended, but he has been dismissed. Any so-called threat has faded, Your Worship. It is of particular importance to note that the applicant has made under oath an irrevocable undertaking not to interfere with the investigations in any way, shape, or form. He sets that out under oath. The last aspect, in as far as interfering with possible witnesses is concerned, it was alleged by the investigating officer that the second applicant indicated that he feared for his life, and this also included the fact that fearing for his life against his co-accused. Well, what do we know? This court knows now that all the applicants before this honorable court, save for the fifth applicant, have at one point or the other, in this very same court, in the holding cells, been kept together. In no form of harm has befallen the second applicant. In fact, the second applicant, who has a mouthpiece, who can speak on his behalf, has made no mention of any threats that he received, nor did he make any mention that he at any point indicated that he was afraid for his life. And on this, Your Worship, I submit that the applicant will not tamper with any evidence here. And as far as section 64D of the Act is concerned, it is tried that the provisions of that section, that is 64D, must be read with the provisions of section 64.8A to D. And Your Worship, I beg your leave just to highlight what 64.8 states. It says, in considering whether the grounds in subsection 4D have been established, the court may, where applicable, take into account the following factors, namely A, the fact that the accused, knowing it to be false, supplied false information at the time of his arrest, of his or her arrest, my apologies, Your Worship, or during the bail proceedings. Whether the accused is in custody on another charge, or whether the accused is on parole. Any previous failure on the part of the accused to comply with bail conditions, or any indication that he or she will not comply with bail conditions. And it goes on to say any other factor which the court may consider appropriate. But we know for a fact that in this matter, the applicant has not provided any false information to the investigating officers. To the contrary, the investigating officer says he has cooperated fully. We know that he's not in custody in respect of any other matter, And that is a fact before this honorable court. It is not in dispute. We know that he is not on parole, that he has not previously failed to comply with any bail conditions, and therefore the facts speak for themselves. And I will respectfully submit that if admitted on bail, the applicant will in no way jeopardize or undermine the criminal justice system or the bail system. And this is as set out in his affidavit as well. I refer this honorable court to paragraph 36 of Exhibit A1. Your Worship, I turn now to deal with the provisions of Section 64E of the Act. The investigating officer testified that he had a fear that the release of these applicants on bail may spark violence amongst members of the community and that they may take their law into their own hands. He testified that Bloemfontein Celtic Supporters Club, which he later conceded no longer exists, had been picketing outside court. But when put...
It's a wrong submission. He had never testified to the effect that they are no longer in existence.
He did, Your Worship. He did, Your
He
Worship.
said they are no longer in
Yes.
existence.
Yes, when I put the question to him, he said, I was told it no longer exists. That was the response that we got. It was sold. The football club, yes. Yes, the football club. I apologize, Your Worship.
Yes.
My learned colleague is correct.
When you say supporters, then again...
As the court pleases, Your Worship. And I apologize for that. My learned colleague seems to be well versed with the happenings of the city. Your Worship, so he concedes that the football club no longer exists. But further, and more importantly, when it was put to him how many people have been picketing, he said, I accept it was less than 50. Your Worship, I do not know. How do we stretch an unrest from 50 people to say that there's a reasonable fear of harm? And keeping in mind that the likelihood is as defined by Klechla J. When under cross-examination, the IO conceded that on the 12th of May, there was no protest. On the 16th of May, there was no protest. On the 19th of May, there was no protest. And this outcry, Your Worship, I submit, is non-existent. Your Worship will note that this court is in a privileged position in that this court has already admitted one of the accused persons on bail. It granted accused number 2, 10,000 rands bail. And nowhere in the testimony by the respondent's witness was it mentioned that there was an outroar, there was an outcry, there was public violence. None of those happened. It never happened, Your Worship. In light of this, Your Worship, it is clear that there's no likelihood that the release of the applicant on bail would in any way, spark a public outcry. It is therefore my submission, Your Worship, that none of the factors set out in section 64A to E exist herein, and as such, the interest of justice dictate that the applicant be released on bail. However, and in the unlikely event that this honorable court finds that one of the grounds of 64A to E exists herein, it is my submission that the provisions of section 69A to G are then triggered, and it is for the court to now weigh the interest of justice to the rights of the accused. And I refer this honorable court to the matter of Jacobus Stephanus Jobs Nell and others versus the state at paragraph 26, and the citation is Nell and others VS open bracket A508 stroke 2017, that would be 2017, open bracket 2017, close bracket ZAGPJHC 296. Alternatively, the same citation, Your Worship, or rather the same case may be found in 2018-1 SACR 576. Paragraph of particular importance is paragraph 26, where it says, upon a consideration of the factors, of the totality of the factors set out in section 68, capital A, it is clear that they are not to be read individually, but jointly, the one following upon the other. Whilst the court notes that there were protests for bail to be refused, my apologies, Your Worship. Whilst the court notes that there were protests for bail to be refused, that there has been an outcry on social media, the question remains, even though the magistrate had found that the likelihood that the release of the applicant would disturb the public order or undermine public peace and security, whether a consideration of section 69 could have mitigated this aspect. The magistrate failed to consider the provisions of section 69, which on its own is a material misdirection when regard is had to the Dlamini case. Close quote. Furthermore, it is my submission, Your Worship, that section 35(1)(f) makes it clear that the interests of justice are paramount, and so does section 64 of the Act itself. That would be the Criminal Procedure Act. The factors listed in section 64 are not conclusive of the question of the interest of justice. They are pointers in an overall inquiry of what the interest of justice might require. The court must decide after an evaluation where the interests of justice lie. And in considering the provisions of section 69, Your Worship, firstly, due regard must be had for the period that the accused has spent in custody since his arrest. And we know now that the applicant, that's applicant number 1, has spent 1 month and 14 days in custody. Regard must be had to the probable period of detention until the disposal or conclusion of the trial if the accused is not released on bail. It was testified in this very court that investigations alone may take a period of 1 to 2 months, and that there are imminent arrests that are coming. So, Your Worship, with that in mind, we accept that there may not be, but there may also be a question of bail applications that this court still needs to entertain, pre-trial processes that still need to happen, perhaps transfers to different courts, which I accept will happen, and only then will this trial commence. The trial, Your Worship, not finalized, but commence. So it means there will be a lengthy delay before this matter will go to trial. It's important that the court also looks at the reason for the delay in any disposal or conclusion of the trial and any fault on the part of the accused with regard to such delay. This matter we know. The applicant was legally represented from day number 1, and at all material times, the applicant abided by the court's order, did not waste this court's time. In fact, at times, Your Worship, the applicant was in a position to proceed with bail. New information would come up, then that would have to be reconsidered. New accused persons would be arrested, then the bail would not proceed. So we know that in all honesty, he cannot be blamed for any delay here. Any financial loss which the accused may suffer owing to his or her detention must also be considered. We know that the applicant is engaged in a labor dispute with his erstwhile employer, and that is before the CCMA. We know that the applicant was in the process of lodging UIF claims, and that also was in the process, and he was arrested prior to doing that. Both of those are monetary in nature. Thirdly, Your Worship, we know, although the investigating officer that did not know, and he correctly said so, said, I do not know of these odd jobs, and I do not know of this gambling that I'm told about. But we know that the applicant under oath says, I have been doing odd jobs, and I have been doing gambling, and I generated an income from these sources. And I submit that there would be a great deal, Your Worship, of harm that would befall him, in that he would lose financially if kept in custody. Your Worship, I'm moving towards the tail end of my argument. Of particular importance is E, any impediment to the preparation of the accused's defense or any delay in obtaining legal representation which may be brought about by the detention of the accused. This court is well aware that the accused is being kept in Goedemond prison, that is in Aluel North. It is common cause that the legal representative, as I stand, for the applicant, am based in Bloemfontein. Your Worship, not only would consultations be very difficult, but it would be financially crippling on the applicant. If I'm not mistaken, Your Worship, it's about a 2-hour drive from here to Aluel North. On traveling time alone, Your Worship, the applicant stands to lose a lot of money. We know there's a CCMA matter. My apologies, Your Worship. Now I'm putting the cart before the horses. It therefore follows that the discussions, consultations, which the applicant needs to have with his attorney would be severely affected if he is kept in prison. And more so, in as far as the CCMA matter is concerned and his UIF claim is concerned. Your Worship, I submit that from the above, it is clear that the interest of justice, my apologies, Your Worship, that the interest of justice dictate that the accused be granted bail. In conclusion, there has been a plethora of cases which have made it and said, if there is no risk of an applicant absconding, bail is to be granted. If there's no risk of the applicant absconding, bail is to be granted. And in this regard, Your Worship, I will not burden the court by reading verbatim. I'll quote a few authorities. S versus Anderson, it's 1991, open bracket 1, SACR 525, open bracket C, close bracket, and that, Your Worship, you will find on page 527. Same view held in S versus Hudson. It's a 1996 matter, open bracket 1, SACR 431, open bracket W, close bracket, at 300 and, my apologies, at 434. Bailey and others versus the state. It's a 2013 matter, ZAK, Z, P, HC 72, and that is at paragraph 29. And Anderson was also held that bail should not be withheld as a form of anticipatory punishment. In S versus Blanco, 2002, 1, SACR 531, W at 537. It was held that a court should always consider suitable bail conditions as opposed to denying bail. Lekhodi J as he then was in S versus DV 2012 2 SACR 4492 open bracket GMP at paragraph 8 found that cumulatively the fact that the state was subject to that the state's case was subject to some doubt, the low risk pertaining to the flight, the absence of likelihood of interference with state witnesses, and the low risk of reoffending constituted exceptional circumstances. Exceptional circumstances, and even higher test. Now I submit that it would meet the test. It is in the interest of justice that the first applicant be released on bail. As the court pleases. Your Worship, perhaps?
Before you
Yes,
proceed
yes.
to another applicant, and I know, as a matter of fact, that a right to a fair trial exists from time and immemorial, and it begins from the time of the arrest of the accused.
Indeed so, Your Worship.
But can you address me the presumption of innocence until
Yes, Your Worship, and it's the matter of Gumbo Fanuel against the state. I do not have the full citation, Your Worship, but I can assure my learned colleague I have not made any notes on it and I'm prepared to hand it up. And I want to refer the court particularly to paragraph 29 of this judgment. It says, the learned magistrate, during delivery of his judgment, it seemed he made provisional finding of guilt of the applicant at page 48 of the record. I have tried many cases of rape. I have never seen a case where an accused person will rape somebody where there would be a witness. Your Worship, that on its own is clear. But if a magistrate, sitting as you are sitting, now wants to make a finding in as far as the guilt or otherwise of the applicant, it goes over and beyond. And Your Worship, I quoted just one part, and I implore the court to perhaps read through this judgment, and I can confirm that it sustains my argument equally. If the court, with the court's leave, may I hand it up?
Does that submission goes along with the saying that right to be presumed innocent,
Yes, Your Worship.
it is not for pre-trial proceedings, it is for trial. Does it confirm the same?
That the right to be presumed innocent?
Yes, it is not the issue to be determined during these interlocutory proceedings, but it is a right to be much entertained during trial.
No, Your Worship. The right to be presumed innocent is not a determination that this court needs to make. That is a right and it stands. This court, if you were to say that because I'm sitting as a court of a bail, in a bail hearing, I'm sitting here in a bail hearing, it would be improper for the court to accept that. I can then presume that the applicants are guilty because the right to be presumed innocent is a trial right. Because that would be the converse of it. If this court wants to make a determination saying that the right to be presumed innocent is a right that is reserved for trial, that would mean up until trial, and in those interlocutory applications, an applicant would be presumed guilty. That would not rise to the standard, the constitutional standard of this country, Your Worship. And that is my respectful submission of the subject.
Right.
If I may, Your Worship, hand up the judgment of Undo. As the court pleases.
Right, another aspect.
Yes, Your Worship.
You say the testimony of Lieutenant Colonel Flyman was based on the wrong premise that the applicant had access to the records
Indeed so.
and therefore knows the witnesses.
I did not go to that extent, Your Worship, and I can perhaps assist the court as to where I was going.
Yes.
In his testimony, Colonel Flyman testified that he is of the view that the applicant, having been a supervisor at G4S, would have had access to personnel records and would know the addresses of possible witnesses. And it was put to him that personnel records, and I personally put that to him, are not handled by supervisors, but by human resource. And he could not dispute that.
Yes, but as I also understood him, his reaction to that aspect was not limited to that. He went as far as to say, on the basis that they are co-employees, then he knows the witnesses.
And Your Worship, I believe that that aspect has been properly canvassed by Lehodi J in the matter that I quoted earlier. And this is where a senior park ranger was arrested and there was a belief that he would interfere with witnesses. And this is where the test came in as to, once he had been suspended, he was no longer a threat. What do we know? The applicant is not suspended. He was dismissed. How then can he be a threat?
Yes, but do you concede that his evidence was not limited to what you have told the court, but he went as far as to say, on the basis of the fact that they are co-employees, he knows the witnesses?
Indeed so, Your Worship. That I will concede.
And another aspect, You also argue to say for the fear that applicant number 2 is having, the court must note that all the accused had been appearing before this court and they had been held in the cells or same cell here in court.
Yes, Your Worship.
And no complaint was ever reported.
Indeed so, Your Worship.
But now, what will be your reaction in respect of the highlighted fact that though they are kept in the cells or same cells, they are being monitored? The issue was canvassed during re-examination of the witness.
Your Worship, this court must not lose sight that was canvassed during re-exam.
Yes.
When it was put to him in cross-examination, that is the investigating officer, he indicated, I do not work at court. Now I will submit that what he responded in re-exam was nothing but an afterthought, Your Worship. He would not, if he has already said, I do not work at court, so I would not know how that works, how then can we, or can this court, honestly accept that his subsequent version is true? In other words, Your Worship, if it was put to him that they stay there, if he genuinely known, and this is my respectful submission, Your Worship, if he genuinely knew what is going on, he ought to have said, well, I know for a fact that they are kept and they are being monitored and all of that. But his honest response was, I do not work at court. I do not know.
Thank you.
So court pleases, Your Worship.
You may go forth.
So court pleases, Your Worship. Your Worship, the arguments in as far as the fourth applicant are concerned are more or less similar, and the case law relied upon would be similar. With your leave, Your Worship, I have prepared written heads. May I perhaps touch on aspects in as far as his personal circumstances are concerned, and assure the court that I still rely on the same case law that I have in as far as the first applicant is concerned, Your Worship. Alternatively, I am prepared to start the argument from scratch.
Yes, just to avoid unnecessary repetition.
Yes, Your Worship.
And that is granted. I think it makes sense.
Indeed so.
Because you rely to the same case laws.
Indeed so. Your Worship,
There is no problem with that.
I rely on the same case law. The first difference, Your Worship, is the fourth applicant is only charged with 6 charges. He has spent a total of 23 days in custody. The testimony of the investigating officer was as canvassed in as far as accused number 1 was concerned, and that testimony is what the fourth applicant wishes this court to take into account. The matter of S versus Joan was canvassed, and the applicant will stand by it. The provision of the Criminal Procedure Act, Section 61, is as canvassed. The provisions of the Constitution is as I have already put before this honorable court. The matter of State versus Dlamini is reiterated before the honorable court. And of particular importance, paragraph 52, where Grichla J correctly held that the notion of likelihood means that there must be a probability that a risk will materialize. Possibility, a suspicion will not suffice. Your Worship, in as far as section 64A is concerned, similarly, the fourth applicant does not have any previous conviction, he does not have any pending matters before this honorable court. Therefore, and furthermore, the investigating officer did not in any way mention that the applicant would commit another offense if he were to be admitted on bail. I refer the honorable court to the personal circumstances in as far as the fourth applicant is concerned, as set out in Exhibit B1. That would be the affidavit deposed to on the 11th of May 2023 by the fourth applicant. He is a South African citizen by birth, and contrary to what the investigating officer testified that he does not have a passport, it was proven in court that he in fact has a passport. In re-examination to try and salvage something, an assertion was made that there were 9 stamps. I wish to put it to this court, respectfully so, that it would defy logic for someone who's a flight risk to tender his passport and then try and escape. This is where the state did not know. The investigating officer says he does not have a passport. So there was no, he could have kept it. And if he were a flight risk, as soon as he were released, he would go to one of the borders and run away. An honest man. He hands it in and he says, I do not want it back. Keep it for safekeeping. And I'm glad, Your Worship, that the investigating officer did in fact retain the passport. Retain it and not return it, as the court pleases. Your Worship, an assertion was made that the applicant used to work, and perhaps I'm indebted to the court for this clarification, that the applicant used to work with some of the witnesses that are coming to testify here. And I wish to once more refer the Honorable Court to the meticulously penned judgment of Lekhodi J, as he then was, where he says, once one is out of the employment, the long and short of it is, there's no harm of interference. In fact, the IO conceded there has been no threats, no tangible evidence. We return again to the word likelihood, Your Worship. And even the fourth applicant has under oath stated that he will not interfere in any way with the investigation. Similarly, we make the same submissions, including those that came and arose from the court's questions, in as far as the purported fear of the second applicant. To say the second applicant is here. This court, when I sit down, his legal representative will be on his feet. You can ask him, has your client indicated any fear? And I can assure you, Your Worship, as we had learned in cross-examination on behalf of the second applicant, there has been no such mention, no such fear mentioned. Your Worship, at no point did the fourth applicant supply false information to the police. Similar to the first applicant, the investigating officer correctly conceded to say, this applicant abided and cooperated, my apologies, the word used was cooperated with me. He's not out on bail on a different charge. He's not in custody on a different charge. He's not out on parole. He has not failed to comply with any bail conditions. And therefore, there is no way where this court could say that he contravenes the specific provisions. He will not jeopardize or undermine the criminal justice system in any way. Your Worship, we have already canvassed the issue of protest. We have already canvassed the issue of an accused person who I beg this court to use as the base test. As an accused person who has already been released on bail, absolutely no outcry, none whatsoever. Your Worship, we once more say that none of the grounds which are set out in section 60, 4A to E are applicable here. But in that unlikely event that this court finds that one of those is applicable, we wish to refer the court once more to the matter of Jacobus, Stephanus, Jobs, Nell, and others versus the state. And we can put the following before this court. The accused has been in custody for 24 days. On the investigating officer's version, we know that it's going to take 2 months, and this court requested that I not repeat myself. But I will still say, Your Worship, that the imminent arrest, the pre-trial procedures will take a long time. And we can therefore accept that there's a great likelihood that even in the next 6 months, the trial would not have commenced. There's been no fault that could be attributed to the applicant in as far as any delays in this matter. Joined this party very late, but when the court invited him and afforded him his constitutional right to bring a bail application, he was ready, the bail was moved, and we are here now, arguing. Your Worship, it is not in dispute that the applicant is still waiting for his pension payout. This is now in as far as financial loss is concerned. It is yet to be paid. Your Worship, there could be a plethora of reasons. And with that said, the applicant would need to personally attend to these issues, sort them out, then gain his livelihood. We know he too has a CCMA case. He needs to consult. He needs to make sure that he gives instructions to his legal representative in as far as the labor matter is concerned. Also needs to give instructions to his attorney as I stand. And Your Worship, I submit that it would be in the best interest of justice if he were to be released on bail. It was not disputed how he generated income. The investigating officer correctly considered he does not know. He does not know of these odd jobs. He does not know of this gambling. He did not say it is not true. He said, I do not know. And I submit, Your Worship, that the interest of justice do dictate that the accused be released on bail. Your Worship, in conclusion, I'll refer to the authorities that I referred to, S versus Anderson, S versus Hedson, Bailey and others versus the state, S versus Anderson in as far as bail should not be withheld as a form of anticipatory punishment, S versus Blanco, where it was held that the court should always consider suitable bail conditions as opposed to denying bail. And of particular importance, the matter where the Hodi JSE then was presided in S versus DV, where he indicated that some doubt, the low risk pertaining to flight, the absence of interference with the state witnesses, and the low risk of reoffending constituted exceptional circumstances. And once more say, if that is good enough for the higher test, it meets and surpasses the test of the interest of justice. I will make the same submissions in as far as the state case is concerned, and those, Your Worship, will be my submissions in as far as applicant number 1 and 4 is concerned. I am armed with the heads of arguments, Your Worship. With your leave, may I hand them up.
Yes. Is it still your contention in respect of applicant number 4,
Yes, Your Worship.
that state case is porous?
Indeed so, Your Worship. It's even worse in as far as applicant number 4 is concerned. The state is relying on monies between two people, applicant number 1 and applicant number 4. And what the state then says is, after the fact, there was a 14,000 transferred between these two applicants. And it is that 14,000 that makes our case very strong. Nothing else was advanced. In fact, in cross-examination, as far as the fourth applicant was concerned, when it was put to the investigating officer that the fourth applicant will come and testify and say, if he, on the night of 3 May, had opened any doors, it was in furtherance of his duties. He agreed. He said, I cannot contest that. Your Worship, I believe that the case, in as far as the fourth applicant, and in fact, in as far as both the applicants whom I represent, it's extremely weak. It has been hyped up, but nothing came of it. Mr. Court, please.
Thank you, Mr.
Your Worship,
Mururi.
may I turn my back on you to take an instruction from both my clients simultaneously?
You may.
Mr. Court. As the court pleases, Your Worship. Your Worship, those would be the submissions. As the court pleases.
Thank you.
Thank you, Worship. As I indicated earlier on, I'm on record on behalf of applicant 2 in this matter. And Worship, we all know that the system that is applicable in the Republic of South Africa, insofar as Schedule 5 bail applications are concerned, is for the court to exercise its judicial discretion correctly, and in that process to order the detention of an accused person, and the court should allow the accused person to present evidence that would satisfy the interest of justice so that the accused can be released on bail. This task, Your Worship, is not given to the NPA. This task is not even given to the NPA, but to the court to exercise its discretion. And it's in common cause that the bail application that we faced with herein falls within the ambit of Schedule 5. And I submit that so because of the accused has a previous conviction of stock theft that occurred more than 16 years ago. This bail application, therefore, has to be considered in terms of Section 60, 11B of the Criminal Procedure Act 51 of 1977 as amended. And it's my submission, Your Worship, that Section 60, 11C does not apply to this bail application. And according to this section, Your Worship, Section 6011, when accused has been charged with an offense referred to in Schedule 5, the test is lower as compared to what the charge would be in Schedule 6. Now, in this matter, Your Worship, what happened is that the accused is facing 3 counts of fraud, 2 counts of violation of a body, the 2 counts of contravention of PRECA, arson, contravention of Section 115 of Act 111 of 1998, and defeating the ends of justice. During the hearing of the bail application, the legal representative on behalf of the accused, being myself, read the applicant's affidavit duly commissioned into the records, and that was marked as an Exhibit C1 by the Honorable Learned Magistrate. The state, in rebuttal, then called an investigating officer, Lieutenant Colonel Flyman, who testified under oath informing the court about his attitude towards the bail, personal circumstances of the appellant or the applicant, I beg my pardon, and the role each applicant played in the commission of charges preferred. He indicated and confirmed to the court that the applicant is staying in Bloemfontein in the house that is on his name. He resides there with his wife, whom he recently married just before the escape with 4 children. The accused says in his affidavit that he's staying with 7 children in that particular house. He confirmed, Your Worship, that the accused indeed has assets, among others cows, that he would buy and sell. He said the accused is unemployed. He was dismissed at work, and only under cross-examination, he said that he was told that in actual fact, the accused has been dismissed. It's my submission, Your Worship, that this cannot be correct, seeing that the accused was on leave on the day he was arrested. That's the 11th of April, 2023, meaning he is still employed at this institution where he is working. He confirmed that the accused has no passport, has no pending cases against him, except this stock theft that I have already referred to. He says in his evidence, the accused wanted to speak and call the police officer, who for one reason or the other happened to be one of the investigating officers as they investigate this matter in a team. And they met at the local mall called Mimosa, and that is where the accused was arrested, or where the arrest took place. The version of the accused, insofar as this matter is concerned, contradicts what the investigating officer said. The applicant says he was called by the police to meet them at the said mall. Therefore, it is incorrect to say he's the one who called the police. If the version of the IO is then correct on this issue, he is not in a position to can explain how the applicant would have got hold of these numbers or would have known the numbers of this investigating official. It's common cause, Your Worship, that it doesn't need an intelligence of a scientist to know that it's very difficult to obtain the telephone numbers of any SAPS member at the local office. It will even be more harder to obtain the telephone numbers of a person working by the Hawks. It's my submission that the IO knows it himself, that he was wrong in this regard to say that the accused is the one who called the police. And I'm going to request this court to accept the version of the accused as being probable. We're not going to lose sight of the fact that the IO admitted that it is human to err. Your Worship, it's not in dispute that what's contained in the affidavit of the accused or the applicant in this matter, it's correct. He doesn't have enough blankets at the detention center, which is in Sosselbeek. And as a result, he contracted flu. No relevant treatment or medication to dispense, as the accused indicated. It's also not in dispute, as per the affidavit, that being in custody would impair his ability to properly prepare and instruct his legal representative, as he will not be in a position to go and consult possible witnesses he might have and present them to the legal representative for consultation in order to prepare his defense. And this is not rebutted in any form in evidence from the state. Your Worship, I just want to add on this that the accused is detained in Sasolburg. It's quite a distance from Bloemfontein to drive to Sasolburg. He is indigent, and that is why Legal Aid came on board for his assistance. Legal Aid South Africa came on board to assist him in this regard. And unfortunately, Legal Aid doesn't have those resources to can commit between Bloemfontein and Sasolburg if this court is going to deny the applicant in this matter bail. It's also common cause, Your Worship, that the applicant is unlikely to evade his trial. It has been cleared on his affidavit. He has not made any threats to any person. The applicant doesn't know the witnesses against him in this matter. And just a reminder, Your Worship, that the accused is not employed by G4S or even the Department of Correctional Services like everyone else employed at that institution. He is employed by the private company called Tegriton Security. The applicant indicated that should he be released on bail, he will stand his trial and attend all court appearances as he wishes to prove his innocence in this matter. It's also not in dispute that from the investigating officer's testimony, he still needs a month or two to complete his investigations. The applicant has already spent 6 weeks, is on his 7th week now in custody, and the investigations are still not yet complete. We do not know at this stage, Your Worship, what is still outstanding, except to be told that other people still has to be arrested. I'm going to submit the following, Your Worship, as the reasons for the state to oppose bail on behalf of Dipolo James Teboho, as outlined by the investigating officer in this matter. He said the following: the administration of justice will be undermined if the applicant is released on bail. He further said, there's a high-profile matter that was even discussed in Parliament of the Republic of South Africa. The community is outraged as they feel, or they harbor a feeling, that the police are not doing their work. And he further said that applicant 2 in this matter is fearing for his life against his co-accused. Your Worship, we're dealing with a Schedule 5 bail application herein. It's expected from the accused to prove on a balance of probabilities that the interest of justice permits his release on bail. And in the bail application, there are factors that the court has to consider that are enumerated in Section 60, 4A to E of the Criminal Procedure Act 51 of 1977 as amended. These factors that are to be dealt with in finding the likelihood of the grounds set out in section 60 are read with factors set out in section 65, 6, 7, 8A of the Criminal Procedure Act. Now, Your Worship, before we could even look into these factors, I think it would be proper to set out what the learned judge in the matter of Kula versus the state delivered on the 4th of April 2023 in the Northwest Division. The citation, Your Worship, is Kula versus state, open bracket, CAB 02/2023, ANWHC 35. The learned judge, Peterson, said, Section 35, 1F of the Constitution of the Republic of South Africa acknowledges that persons may be arrested and detained for allegedly having committed offenses, but such arrestees are entitled to be released on bail on reasonable conditions should the interest of justice permit. Now, deciding whether the interest of justice permits such release and determining appropriate conditions is an exercise that needs to be performed judicially in accordance with the procedure laid down in the Criminal Procedure Act. It's common cause, Your Worship, that the personal circumstances of the applicant were not placed seriously in issue by the investigating officer, and it is therefore clear that this court should find that in favor of the applicant that he should actually be released on bail. I now tend to deal with these factors that are on 4A, 4A2E. The interest of justice do not permit the release from detention if the release will endanger safety of the public or any particular person, or will commit a Schedule 1 offense. There's absolutely no evidence put before this court that would suggest that the accused, if released on bail, will commit a Schedule 1 offense. Where there is a likelihood that the accused, if released on bail, will attempt to evade his or her trial, very clear before this court that the accused is rooted here in Bloemfontein. The accused has no passport. Accused has no relatives out of the boundaries of the Republic of South Africa. It's a clear indication that based on that, the accused will stand his trial. Is there any likelihood that the accused, if released on bail, he will attempt to influence or intimidate witnesses or to conceal or destroy the evidence? It's also my submission, insofar as this is concerned, that witnesses are unknown to applicant 2 in this matter, unless a list of such witnesses is served upon him. But as at this time, when we busy with this bail application, no witnesses are actually known to the applicant. By the way, Your Worship, we're not going to lose sight of the fact that no hearing was held for applicant 2 in this matter. And it cannot even be said that people who testified against him in that disciplinary hearing are potential witnesses in this matter. That assertion does not hold. It's not here. It's not going to help us in any way, because there was absolutely no hearing for the applicant at Tegregon Securities. Whether there's a likelihood that the accused, if it's released, will undermine or jeopardize the objective or the proper functioning of the criminal justice system, including bail system. Your Worship, there is before I just come into the issue of a higher test in 4E, we're told that there is a group of people who are against the release of the accused, and they are the supporters of one team called, or used to be called, Celtics. And as my learned colleague put forth a question to the investigating officer, it was said that this is a handful of people who are less than 50 at any given time. Your Worship, I want to submit that this is one issue that was canvassed also with the investigating officer, that there's a group of people that want justice for one late Bereng. And unfortunately, my take, or one I conveyed to the investigating officer on that particular day, was that they are of the view that the accused before this court, now I refer now specifically to accused number 3, applicant number 2, took part in the demise of the late Bereng. It is unfortunate, Your Worship, that accused 3 is not facing any charges of murder, and this has not been correctly conveyed to the Celtic supporters to understand what this is all about. Now let's move over to a higher test of 4E in this matter, where there is a likelihood that the release of the accused will disturb the public order or undermine the public peace or security. Your Worship, it's my submission that in this matter, accused 2 is already released on a bail of 10,000 rand. And nothing has happened ever since. He was released into the very same community, facing charges similar to what these accused persons are facing, released into the community, nothing has happened. And I do not think that the court would want to separate the issues here, that because accused 2 stays out of the jurisdiction of this area, therefore the people that are within the jurisdiction of this area are not entitled to be released on bail. I do not think that is the direction that this court would really want to take. There's never been unrest since this second accused was released. This matter has been in the public domain, as I argued, as I took it over with the investigating officer more than a year ago, and nothing has happened. He says this matter got into the public domain as early as March this year, this calendar year. And Your Worship, we all know that this matter has been in the public domain from what Judge Cameron said when he handed it over to Ground Up to investigate in September 2022. And nothing. The accused have been staying at his place. Nothing has happened. And Worship, what I'm saying is, as my learned colleague has said, what is required is a likelihood of undermining the public peace and disturbing the public order, not a mere possibility. If this court is going to look into the factors that are presented before it, the magistrate may also impose a suitable condition to deal with that matter. Whether there will be an outcry as the investigating officer testified before this court, we are also told that there are factors that the court has to consider. Whether the nature of the offense or the circumstances under which the offense was committed is likely to induce shock or outrage. Whether the safety of the accused might be jeopardized by his release. Whether the release of the accused will undermine or jeopardize the public confidence in the criminal system. Your Worship, this matter has been settled in the matter that my colleague has already outlined before this court, in the matter of State versus Dlamini, 1999, 2 SACR 51 CC, where the learned Judge Krikla said, it is important to note that subsection 4E expressly postulates that it is come to play only in exceptional circumstances, which I've already said that it's of a higher case. There's a clear pointer that this unusual category of factors is to be taken into account only in those rare cases where it is really justified. What is more, subsection 4E also expressly stipulates that a finding of such circumstances has to be established on a preponderance of probabilities. Lastly, once the existence of such circumstances has been established, paragraph E must still be weighed against the considerations enumerated in subsection 9 before a decision has been made. My learned colleague has already referred to what are those factors that the court should consider dealing with subsection 9 of this Criminal Procedure Act. The judicial officer will therefore rely on this ground with great circumspection in the knowledge that the Constitution protects the liberty interests of all. Close quotes. The magistrate cannot be influenced by the events which manifest themselves on the media, comments on Twitter, and protesters who gathered before the court opposing the release of the accused on bail. The magistrate has to deal with the issue of public outrage, not just pay a lip service to the statutory provisions and apply the provisions of section 69 to mitigate on this aspect of people gathering in order to oppose bail.
Sorry, Mr. Magama, section 69 or 60
subsection 9. 69. It's our submission that there was no outcry based on what we currently have here. Accused 2, as I indicated, Your Worship, was released on bail and no evidence was submitted to rebut except the information that we've been given by the investigating officer in this regard to say the community is outraged. These other factors, Your Worship, were also dealt with in the matter of State versus Mafe. The court, I'll just get the citation for the court on this one. The court at paragraph 112 clearly stated, would you recall, Your Worship, that we were told that the accused made some pointing out, covering his head because he was fearing for his life. He was scared of the co-workers. We're told that. We're also told that in one or the other, the accused sort of confessed to the commission of this offense. At paragraph 112 of State versus Mafe, the court relied for the refusal of bail, relied heavily on the pointing outs or what the accused said to the police upon his arrest, which was a confession. It's straight law that bail proceedings on their own nature are sui generis and concerned with the liberty of an individual. There's a right which is enshrined in the Constitution. Our courts, in similar cases, have said that admissibility of pointing outs and purported confessions made by the applicant at this stage is not an issue to be determined by the bail court. It's an issue that is best left to the trial court to consider after all evidence will be tendered before it and a proper determination has been made. At this stage, Your Worship, we don't know as to what were the circumstances of the pointing out, if ever they were made, and the purported confession, if any. We do not know. But as I say that, there's a matter for the trial court. In that very same matter of State versus Mafe, the court went further to say, in addition, the accused person cannot be kept in custody pending his trial as a form of punishment. We're not going to lose sight of the fact that these type of matters take long to investigate and to finalize. As we are already aware, the investigating officer said that he needed a month or two to complete his investigation. It's not yet clear what's outstanding. It's not yet clear how many people are still to be arrested. But the fact that there is still a possibility of investigation going on, that means that the accused may be kept in custody for the longest time ever, pending the investigation. The investigating officer went further to say that the people are saying the police are not doing their work. That's one other reason we request this court to refuse bail on behalf of the accused persons. Now, one wonders, Your Worship, as to whether the accused should be kept in custody as a form of punishment to adhere to what the investigating officer requested, or to prove a point that they are actually doing their work. And the response thereto, Your Worship, is a no. And as I'm saying that this matter was also canvassed and dealt with, seen to be unconstitutional, and was confirmed in the matter of State versus Bennett, 1976, 3 SA 652 at page 655. The court said, detaining an accused person for purposes of investigation and consequently in so doing will frustrate the applicant's constitutional right to be detained without lawful and just cause. Generally, courts grant bail to an accused person unless there's a likelihood to prejudice the ends of justice. We all know that this matter was also confirmed in the Constitutional Court, where an observation was made that the interest of justice is to grant bail to focus primarily on securing the attendance of the accused at trial and on preventing the accused from interfering with the proper investigation and prosecution of the case. I've already dealt with these issues. Your Worship, the court must also consider the fact that the accused handed himself over to the police, cooperated with them. He still intends to cooperate in whatever manner that he would be required to do so. It's therefore my submission, Your Worship, that there is no evidence placed before this court that the accused will become a fugitive should he be granted bail. The accused has no pending cases against him, except this one that's keeping him in custody for a period of more than 7 weeks already. No outstanding warrants against him. He has this previous conviction of 2017. No passport. No evidence before this court that an accused person is a violent person. It cannot be disputed, therefore, that the witnesses are also unknown to him. And it's my submission, Your Worship, that the accused or the applicant made submissions before this honorable court that complied with and satisfied the requirements of Section 60(11)(b) of the Criminal Procedure Act, and is therefore entitled to be released on bail. Your Worship, I just want to deal with one aspect that was posed to my learned colleague, that the accused, when they are here in custody, they are being monitored. Your Worship, I just don't understand how would this court say that is a fact on its own. Yes, we all know that they are being monitored when they're before the court. But if the accused...
No, sorry to interject. The court meant to say, as a matter of fact, as per evidence before me.
Yes.
Yes, not the truthfulness of what was said.
That's correct, Your Worship. The evidence before this court, I do not think that that evidence should be taken as the truth, as a fact, because the accused are also saying, insofar as that is concerned, that they have no issues with each other. This is something that weighs heavily against the version that that says they are being guarded herein.
But is that piece of evidence before me?
Your Worship, Your Worship, I'm saying this is what if the court can look into the affidavit. If the accused denies allegations leveled against him, in a nutshell, he means these are some of the issues that he will deny. I'm not saying that the evidence of them is specifically before this court, but I'm making an inference from what is already before the court.
But it is expected from you to address me on the evidence that is...
Fully agreed. I fully agree, Your Worship.
Yes,
but I'm saying...
And I cannot, draw inference on the aspect that you are drawing me to. Because when you say you meant, or it was meant to say in respect of whatever that may be said against them, they will deny it. My understanding was that allegations as per the charges preferred against them.
Fully agree with the court on this aspect, Your Worship. I'm not going to take it any further, but what I'm saying to the court is that, Your Worship, by stating the fact that they are denying, especially accused 3, he is denying such averments in his affidavit, it then means that it has a bearing on that piece of evidence that is before this court. Yes, Your Worship, as I indicated, you get that mathematics. The this doesn't give me the perfect citation, Your Worship, but this is a matter that was held in the High Court of South Africa, Western Cape Division, case number A49/22, and is a Western Cape Division. This matter, the judgment was delivered on the 31st of May 2022. As if there is any other aspect that this court would like to hear me upon, it's my submission, as I indicated before, Your Worship, that the accused is entitled to be released on bail as he has satisfied the requirements of the said section.
Reference that you just made, it is in relation to State versus Mafia.
State versus Mafia, yes.
Right, I heard when you make your submissions that the applicant is suffering from impecuniosity.
From?
From impecuniosity. You said he is indigent.
Yes, yes.
I do see, according to his affidavit, he offered a bail of 500 rands, rather 5,000 rands.
Correct, yes.
Amount of bail that is far beyond than the bail money that is offered by other co-applicants. I just want to check, if you say he is indigent, how possible is making such a huge amount of money?
Well, Your Worship, I'm not aware of what other applicants said or offered. But you'd recall that the investigating officer himself testified before this court that the accused is left with 3 cows and he conducts the buy and sale of the cattle. In this 3 that is left, in order for them to make that available, they had to sell a cow. So, meaning at this stage they're left with 2. So that's the kind of business that he is currently doing. Because as we indicated that the last time that he was employed, it's on the 10th of April 2023, and since then he has never got any salary whatsoever. So that's basically how he's making his living.
Okay, I just want to be sure, did I hear you correctly? When you concluded, you said applicant does not know the witnesses.
That's correct. That's correct. He doesn't know the potential witnesses, people who may come and testify. Yeah, he doesn't know them. They are unknown to him.
But how do you then address the contradiction as per what you are submitting before me with paragraph 6.4 of Exhibit C1? We have a latitude to
What is the 6.4?
yes.
No, Your Worship, I think it's a issue on my part to say that it. I mean, if you read this in context, it says, "I respectfully submit that I have also not made any threat of any sort and any nature to any person involved in this matter against me. I also do not, actually should have read, do not know."
Yeah, but before me, it was read like that. It is not saying do not. And that is how I understood it. Even if I read in context of what you have already submitted, it does make sense in that fashion.
Yeah, but Your Worship, clearly, this is very clear. It goes even further to say that as such, undertake not to contact or attempt to contact any of the state witnesses.
Yes,
they
despite
are unknown.
knowing them, I don't have that intention to contact them.
Yes, no. If this has to be read in context, the entire paragraph has to be read in context. You're not going to isolate in order just to come to a conclusion that is not even justifiable in this regard. What we are saying here, in Your Worship, is that if you read this paragraph, it's just a misnomer on my part to have said that I also do not know. I do not know. I mean, if no hearing was held for him, how would it be expected of him to know the witnesses? I am correcting this now as we speak to say that these witnesses are actually unknown to him.
Yeah. Now, I was just bringing it to your attention. It is evidence that is before me.
Granted, Your Worship, but evidence can be corrected at any given time before judgment.
Yes, thank you.
Yes.
Any other thing you want to bring to my attention?
No. I think I've made out my case.
Thank you.
Thank you.
Mr. Kwenane?
If Your Worship need us to take 5-minute break, I would move that, Your Worship.
You are requesting 5 minutes.
Indeed, Your Worship. Please, is the court, Your Worship.
Okay. Let me hear from Mr. Botha.
I will proceed for 5-minute break. Absolutely.
Mr. Mako?
It's now 20 to 1. We break for 5 minutes, which will take us then to 1:45. We proceed for 15 minutes, which take us to lunch, and there will be proposal for lunch. I would rather suggest that we take an earlier lunch. I don't know, I know Mr. Mururi has commitments of taking a child from school at lunch. I'm not sure. If I would suggest that we take a lunch break now until 1:30. Exactly 1:30, we come and shoot. That will be my suggestion.
Save for the shooting part, I agree with my limit. I do not intend to shoot anybody. That's the good piece.
I withdraw the shooting.
Thank you. Mr. Magameli?
I just conferred with my learned colleague. I think he's more than willing to proceed and so that we can adjourn at 1 o'clock.
Actually, we needed only 5 minutes, but I'm just mindful of the fact that if we proceed as my learned colleague proposes to me, and knowing that he's my friend, I didn't want to differ with him, I'm just worried that we still would not actually finish off by 1 o'clock. I therefore am going to propose that we actually follow what has been proposed by my learned colleague of the prosecution, that we have an early lunch. I'll sort out the other one with my friend. God please.
Yeah, Mr. Magameli, will you surrender now?
No, I'll survive. I'll survive.
Thank you. Then court adjourns until 1:30.
was for Mr. Kwenani now to address the court. Yes?
Thank you. Mr. Benani?
I thank the court, Your Worship. I particularly thank the court for the indulgence. If I may, I am ready to start with the leave of the court, Your Worship.
Yes, you may proceed.
When everything has been said and done, we need to bear in mind what constitutes bail, or what is the purpose of bail. Purpose of bail is actually encapsulated in deterring the further crime by the accused person. And secondly, is to ensure that the accused person comes back to court and basically stand the accusations against him or her. And we know that there are guidelines that actually says when do you give a person a bail and when does the court deny a person bail. Maybe we should not look any further than the decision of Pinheiro. Pinheiro was a decision of Pinheiro. Pinheiro is P-I-N-E-I-R-O. Pinheiro, 1992, volume 1 of South African Criminal Records, SACR 577. It was a Namibian decision. Where at 580C, the following was said. And I'm going to ask that I should actually quote it at length because it actually summarizes everything that actually pertains to our application to have accused number 6 being granted bail. It basically says, in the exercise of the discretion to grant or refuse bail, the court does in principle address only one all-embracing issue. Will the interest of justice be prejudiced if the accused is granted bail? And in this context, it must be borne in mind that if an accused is refused bail in circumstances where he will stand his trial, the interests of justice are also prejudiced. 4 subsidiary questions arise. If released on bail, will the accused stand his trial? Will he interfere with state witnesses or the police investigation? Will he commit further crimes? Will his release be prejudicial to the maintenance of law and order and the security of the state? These are the guidelines that are also outlined in section 60, subsection 40. In that section of the Criminal Procedure Act, they are outlined as follows. Is there a likelihood that the accused would, if released on bail, endanger the safety of the public? Number 2, whether there is a likelihood that the accused, if released on bail, will attempt to evade his or her trial. Number 3, will he intimidate the witnesses? Will he jeopardize the proper functioning of the criminal system? And lastly, but that pertains to exceptional circumstances, is there a likelihood that the release of the accused person would disturb the public order? Basically, that's a guideline. And as far as it pertains to accused number 6, Mr. Buti Masukela, we know that the colonel who testified earlier had said that there is no evidence, direct evidence to say that Mr. Masukela, who is accused number 6, will interfere with the proceedings basically of the investigations. He will not intimidate the witnesses. There isn't such evidence. And we know basically that he was answering those questions in the negative because accused number 6, Your Worship, is a first offender. We don't have history that we can look into and say that Mr. Masukela is a danger to society. We do not have a history to look at and say he is predisposed to violence, he will commit other offenses, and so on. But we also know that the testimony that was given here by the same witness, Colonel, is to the effect that accused number 6 has a permanent place of abode, and that he has been staying there for the past 16 years at least. This gives us an idea that the sense in his life, there's a sense of permanency here. He has 4 children, he's married, he's been staying there permanently. Mind you, Your Worship, we're still looking at the issue of the possibility of evading his trial. We know also now that he does not have a passport and the means of running away. Why are we outlining all these factors, Your Worship? We are outlining these factors because this is exactly what constitutes the interest of justice as we are expected to outline. Maybe we should quote case law, which still says the same thing, but just differently. And maybe what we should do, we should actually look at what Judge Kubushi said in State versus Diala. State versus Diala, 2013, volume 2 of SACR 85. And I quote directly from that case. Judge Kubushi said, quite correctly, a court cannot find the refusal of bail is in the interest of justice merely because there is a risk or a possibility that one or more of the consequences mentioned in section 60 subsection 4 will result. The court must not grope in the dark and speculate. A finding on the probabilities must be made, unquote. I've left the last line there. The court, this honorable court, Your Worship, if it were to decide on whether to grant accused number 6 bail or deny him bail, it will have to strictly look at these factors. Granted, we accept that it is not a ticking of the boxes type of an exercise. But when we look at this case, we know we do not have any direct testimony that says this gentleman will not come back to court to stand trial. We do not have evidence that suggests that accused number 6 will run away or accused number 6 will murder the witnesses or will do anything untoward to the witnesses. This basically says to us that this gentleman, accused number 6, must be taken for what he is when a decision to grant him bail or deny him bail is made. He should be looked at as a man that has got 4 children. He should be looked at as a breadwinner in his household. Who, if this honorable court decides to deny him bail, who will be in a position, who would not be in a position to feed his 4 children? He's a man who would not be in a position to feed his wife. And we should bear in mind, Your Worship, that we do not know how long would it take to finalize this matter. It's not wayward and it's not wrong to think that it could take a very long time for this matter to be finalized. And if that happens, basically we are saying that this man should be placed in a situation where, should he be found not guilty after the trial, he'd go to a non-existent household, which he would have left as home when he was detained. Simply put, we are saying, Your Worship, let us look at this section 60, subsection 4. Let us look at the fact that accused number 6 has a very stable life. He does not have travel documents. Let us look also at the case against him, the strength of the case against him. And we should bear in mind, and maybe I should point this out at this stage, that in instances where there's a very strong case against individuals, such individuals tend to want to run away. But in this case, we know that the alleged role played by accused number 6 pertains to, the alleged thing of not having stopped the car, the van that he was supposed to stop, or not having searched that. Those are the allegations against him. And maybe I might be oversimplifying it, but those are the charges. And indeed, based on that, it is further alleged that he acted in common purpose with other accused. But when one looks at the charges against him, it can hardly be said that the state has such a strong case that could lead to accused number 6 being held for a long time in custody. This has been said in that decision case of Hudson. It's a 1980 case, Hudson, 1980, it was volume 4 SA, which basically said, if it is expected that a person is going to be sentenced for a long time, that actually acts as an incentive for him to abscond. Your Worship, I would like to say to this honorable court, let us look at the available evidence against accused number 6. If indeed it is said that he was acting in cahoots with other people that have been accused, would accused 6 do what it is alleged that he has done and not be paid for whatever he would have done? This is not an isolated question. This is part of the questions that this honorable court has got to ponder on when it looks at the case against accused number 6. Let me also hasten to add that the court should also, in making a decision, should also bear in mind that we raise the issue of the health of the accused. We said that accused number 6 is suffering from diabetes. That is well contained in the affidavit that we handed. I believe it was Exhibit D1, Your Worship. Let me hasten to remind this honorable court that in the case of Osongani, 2012, Volume 1, SACR 292, the SCA said that personal circumstances of an accused, even much more than assets, should determine, or they determine whether the accused is a flight risk. This is a sick man, the man that is suffering from diabetes. This is a man that has got stable home environment. This is a man that has not been committing any offenses. And this is a man whose profile does not say tomorrow he's going to run away. We are saying to this Honorable Court, look at these factors, Your Worship. What we have outlined now, read it in conjunction with that affidavit, and remember the purpose of bail, and grant accused number 6 bail with the full knowledge that he will come and stand his case, his trial basically. I'm not sure if there's any aspect that this Honorable Court would like me to highlight, but before then, let me just check and ask this Honorable Court that I should actually approach my client and see if there's any aspect that you'd like me to highlight. But even before doing that, I'm reminded actually that this gentleman, accused number 6, Your Worship, is still a man employed by G4S. He is still on suspension, and he's a man that needs to go back and work for his family, if I may approach, if it pleases the court, Your Worship. I am indebted to the court for a minute that I've been granted. Your Worship, my client says I should kindly tell this Honorable Court that he's incarcerated out there in Boshoff, and that it is very costly for him to have his attorney to go and consult with him. He says that it will be in the interest of justice that he should be granted bail, because then he can consult and he can prepare easily for the trial. He says that I should say to this Honorable Court that he's got a pending matter of disciplinary hearing which would need him to prepare thoroughly. He says he will indeed come and appear before this Honorable Court, and that if it pleases this court, if the court thinks that there could be any possible risk which we submit we do not see, he says he's even willing, if this court, to be granted bail with conditions that this Honorable Court may deem fit. I thank the court, Your Worship. Unless there are issues that this Honorable Court would like me to address, we will oblige. Indeed, Your Worship.
Yes, having been emphatic on the guidelines as per Pinero's matter, as well as the provisions of Section 6, subsection 4.
Indeed, Your Worship.
May myself and you be at idem that factors as enumerated under the provisions of Section 60, subsection 5 to subsection 9, they do not represent a numerous clauses.
Oh, absolutely, Your Worship. Your Worship, one should bear in mind that in outlining the various subsections of Section 60, we do not believe that the legislatures were somehow imbued with the wisdom of Solomon, which would cover all eventualities. Such wisdom might not even exist. Let me answer the question directly and say, this court, Your Worship, is seized with this matter. And this court would know, having listened to the evidence, this court would know the nuances of this matter. And we are saying we would like to highlight certain aspects, again, not highlight everything, before this honorable court, and say to this honorable court, there have been decisions that were actually made by various courts on facts similar to these. And we say to this honorable court with respect, look at them. Look at those sections that the court has just referred to. And having gathered all facts, come to the conclusion, which in this case of accused number 6, we will plead with this honorable court and say, send him home, he will come back when the right time comes to stand his trial.
Yes, sir, you extended it too much. I just wanted to establish whether we are in agreement that that does not represent a closed list.
I apologize to this honorable court, but indeed I agree that it's not, all those factors do not constitute all possible factors. Pardon me, I'm an old teacher.
Thank you. Thank you, Mr. Kwenan.
I thank the court. Your
Thank you.
Thank you, Worship. May I proceed?
You may proceed.
Worship, let's look at the strength of the state's case against applicant number 5, Worship. Your Worship, the investigating officer considered Colonel Flyman, there's no direct evidence in terms of count 6 that applicant number 5 committed arson or set alight the cell 35 at G4S correctional facility. There's also no evidence during his testimony, Your Worship, that she was in common purpose with other people trying to commit arson, Your Worship. There's no such evidence, Your Worship. So basically on count 6, there's no evidence that applicant number 5 committed an offense of arson. On count 11, Your Worship, defeating the ends of justice, between the dates of 23 April and 2 May 2022, there's no evidence of Colonel Flyman that applicant number 5, with a common purpose, with third parties or people, claimed the body or an unknown body of a person at National Hospital. There's no evidence that applicant number 5 smuggled a dead body into cell 35 at G4S premises. There's no evidence, again, that applicant number 5 set the corpse alight or set the corpse on fire at cell 35 at G4S premises. There's no evidence that applicant number 5 gave the impression that the corpse that was lying in cell 35, that is indeed the corpse of Thabo Bester, Your Worship. The only allegations the state is having in terms of count 8 is, Your Worship, that applicant number 5, they are alleging that applicant number 5 helped Thabo Bester escaped at G4S Correctional Services, Your Worship. But let's look at the facts regarding count 8, assisting Thabo Bester to escape. Colonel Flyman came to testify and stated clearly what is the job description of applicant number 5. That is to monitor the cameras, to monitor movements in the jail or in the correctional facility. That is to open doors, and also to open doors for G4S employees, Your Worship. And what is the evidence in front of this honorable court? Thabo Bester escaped, being camouflaged in G4S uniform, walking out of jail, Your Worship. And with all the respect, Your Worship, that was part of our duties to open doors for G4S employees, Your Worship. We don't know how was he captured on camera, Your Worship, but the end of the day is, the fact is he was camouflaged in the uniform, Your Worship. And there's also no evidence that applicant number 5 provided this uniform to Thabo Bester, Your Worship. It is my submission, Your Worship, that with all the respect, my client has been criminally charged for reporting to duty, doing her daily duties at work, and at the end of the day, she's sitting here as an accused 8, Your Worship. It is my submission that the state does not have a strong case against applicant number 5. And it's stated clearly in State versus Matubela, 2010, Volume 1, SACR 55, between brackets SCA, where the court decided that if regarding the weakness of the state's case, there's an obligation on the applicant to go so far to prove that the possibility being in a trial court, being acquitted, Your Worship. And that is the facts here, Your Worship. With the facts here, we can clearly say to the court with the allegations here, applicant number 5 can be acquitted in a trial court, Your Worship, and there's no strong case against applicant number 5 in this matter. Your Worship, we also, let's look at the circumstances. Applicant number 5 was suspended during July 2022. She was dismissed in December 2022, Your Worship. At this stage, we don't have access to the disciplinary information of G4S, but it's clearly, Your Worship, if she was suspended, there would have been evidence, a possibility. I don't want to speculate now, but somehow, somewhere, she was first suspended based on allegations, Your Worship. Now, more than a year, she's been arrested. The Thabo Bester has escaped, Your Worship. This case was standing still for a year, Your Worship. The investigation is not completed. Colonel Flyman testified more arrest is going to possibly more arrest is going to take place, Your Worship. At the end of the day, how long is this matter going to proceed before it goes on trial? At the end of the day, if bail is denied, applicant number 5 has to wait until she gets a day in court for a fair trial, Your Worship. It will be my submission, Your Worship, that the court can impose strict conditions. It will be my request then the court impose a bail amount between 5 to 10,000 rand, that applicant number 5 reports to the Hedidal police station if the court so directs, Your Worship. At this stage, the identities of the state witnesses is not known to applicant number 5, but the state can give a list of state witnesses to applicant number 5 and inform her, this is the names of the state witnesses. You're not allowed to make contact with state witnesses, because you worship must remember there's a possibility that some of these G4S witnesses, they were colleagues with applicant number 5. So if the state can provide a list and say you're not allowed to make contact with these persons, we will abide by such conditions, Your Worship. Section 64A to E, Your Worship. States very clearly, and I'm going to read as follows. Section 64. The interests of justice do not permit the release from detention of an accused where one or more of the following grounds are established. Where there is a likelihood that the accused, if he or she were released on bail, will endanger the safety of the public or any particular person or commit serious offences. There's no evidence, Your Worship, that applicant number 1 will endanger the safety of the public or any particular person, nor will she commit serious offences, Your Worship. Applicant number 5. Your Worship, she's today here, she's a first offender, no previous convictions, and she hasn't been released on bail that the state can prove, but you did commit further serious offences, Your Worship. Where there's a likelihood that the accused, if he or she will be released on bail, will attempt to evade his or her trial, Your Worship. Your Worship, is my submission during the evidence of Colonel Flyman. He conceded that applicant number 5 was arrested peacefully at the house, Your Worship. It's not like she was trying to run away or they were trying to look for her in Bloemfontein. It is my submission there's no evidence that she tried to evade the trial because her arrest was peacefully, she was peacefully arrested by the South African police at the premises where she's staying. Where there's a likelihood that the accused, if he or she were released on bail, will attempt to influence or intimidate witnesses or to conceal or to destroy evidence. Your Worship, is my submission that Colonel Flyman testified and he conceded it's more than a year that after a year he arrested applicant number 5, and there's no evidence that she tried to intimidate or tried to make contact with witnesses, Your Worship. And it's also my submission that after her arrest on 1 May 2023 until today, until Colonel Flyman finished his testimony, there was no evidence that applicant number 5 tried to make contact or intimidate witnesses. And it is my submission that she tried or will conceal to destroy evidence or tamper with evidence. At this stage, she was dismissed as G4S, if Your Worship, so there's no fear that she will try to interfere with or destroy evidence at G4S because she's no longer working at G4S because she was dismissed, Your Worship. Where there's a likelihood that the accused, if he or she were released on bail, will undermine or jeopardize the objectives or the proper function of the criminal justice system, including the bail system, Your Worship. Your Worship, is my submission regarding 4D. There is no evidence that she will undermine or jeopardize the objectives or proper function of the criminal justice system, Your Worship. That is my submission, and it is my argument that all the legs in terms of section 48 to E stays favorable in applicant number 5's favor, and I ask the court to grant applicant 5 bail, Your Worship. Your Worship, the courts and the bench is independent. Parliament can't dictate for the court, Your Worship. The view of the community also being aggrieved, Your Worship, of Katlego, Your Worship. But at the end of the day, Your Worship, the law, we must apply the law, Your Worship. And there's no evidence that applicant number 5 caused directly the death of the deceased Katlego, Your Worship. And it is my submission that the picketing outside, it clearly states, Your Worship, and there's also boards outside today stating that the people want justice for Katlego, Your Worship. And with all the respect, it is my submission, Your Worship, that my client, applicant number 5, has not been charged for the murder of Katlego, Your Worship. And I ask the Honorable Court to grant applicant number 5 bail, Your Worship. Reasons is she's having 2 children. Her personal circumstances is she's having 2 daughters of 16 years and 7 years. And she is the only primary caregiver of these children. These children is staying with her, Your Worship. The fathers is just contributing financially regarding maintenance, but at the end of the day is applicant number 5 was the sole parent that raised these children, Your Worship. And it's also my submission that if the Honorable Court does not grant applicant number 5 bail, Your Worship, what will happen to the children, Your Worship? It is my submission. The court must also consider regarding, before the court makes a decision, before the court makes a decision to consider that the court grants a bail, that she can go out, look after children, Your Worship, and attend a court on the dates directed by this Honorable Court, Your Worship. I don't know if there's any aspect the court wants me to address the court, Your Worship.
Yes, I'm concerned about one aspect. What informs you to submit that this court cannot be dictated by Parliament? It's given, but what informs you to submit that?
Your Worship, a person would have expected then a memorandum or petition or any form of that is my argument, but the court can rectify me. A memorandum or a petition stating that members of Parliament is opposing bail, but there was only verbal testimony, Worship. It was never read in records of the court, Your Worship.
There is no such evidence before me.
Your Worship.
There is no such evidence before me that the Parliament said perhaps court to decide otherwise. So for you to say I may not be dictated by the Parliament.
Your Worship would remember that Colonel Flyman's testimony was that this matter was in Parliament also. That was his testimony.
Yes, he wasn't suggesting that the Parliament said. Oh, yes.
Yes, Your Worship. No, I just want to elaborate on the court that regarding now, people are in this matter. They're making an anti-elephant, Your Worship, and with all the respect, the court just have to apply the basic principles in terms of the law, Your Worship.
So, in essence, you are saying I may not be dictated by the sentiments out there. I should rather apply the law.
Yes, Your Worship.
What in essence you are saying.
That is indeed so, Your Worship.
Thank you.
I thank the court.
Mr. Matoko, are you ready to proceed?
Yes, I'm ready.
Thank you.
Sure, Your Worship, so much has indeed been said by 1, 2, 3, 4 legal representatives. And as much as I have prepared my arguments before court, I will here and then touch a little bit on what each one of them said. Your Worship, it is indeed so that at the beginning of these proceedings, both the state and the defense, except the legal representative for applicant number 3, who happens to be accused number 6, agreed that the applicants are facing charges falling or in the ambit of Schedule 5 of the Criminal Procedure Act 51 of 1977. The court will recall that Mr. Kwanani initially objected to the schedule insofar as his client is concerned, but the moment he was alerted to the fact that there is a mentioning of common purpose, he immediately considered that indeed is Schedule 5, and he went as far as, when one looks at Exhibit D1 at paragraph 7, under oath, the applicant stated that my legal representative has explained that I'm facing a Schedule 5 bail application. Lordship, amongst others, the charges against the applicant, save for applicant number 5, include corruption in contravention of Section 3A and 3B of the Prevention and Combating of Corrupt Activities Act 12 of 2004, as well as fraud, which the state alleges both the corruption and the fraud to have been committed by a group of persons acting in the execution or furtherance of a common purpose or conspiracy. Amongst others, applicant 1 is facing 5 counts of corruption and 3 counts of fraud. Applicant 2 faces 2 counts of corruption and 3 counts of fraud. Applicant 3 faces 2 counts of fraud. Applicant 4 faces 3 counts of corruption, while applicant 5 faces a count of contravention of Section 115 of Act 111 of 1998 that relates to the assisting of an inmate to escape, as well as a count of defeating the ends of justice. Your Worship, the proceedings were indeed conducted in terms of Section 6011B of the Criminal Procedure Act, which amongst others state as follows, as already been quoted by some of my colleagues here. Notwithstanding any provision of this Act, where an accused is charged with an offense referred to in Schedule 5, but not in Schedule 6, the court shall, my emphasis, order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduces evidence, and I wish to emphasize, adduces evidence which satisfies the court that the interest of justice permits his or her release. Joseph, in State versus Rode, R-O-H-D-E, it's a 2020 case, Volume 1, SACR 329. The Supreme Court of Appeal at paragraph 25 reinforced the principle that the applicants carry the evidential burden on account of Section 60, subsection 11, paragraph B, to persuade the court that the interest of justice permits their release. You should say for applicant number 5, the onus is on the applicants to satisfy the court on a balance of probabilities that the interest of justice permits their release. As much as all the parties agreed at the beginning of these proceedings that the application falls within the ambit of Schedule 5 and therefore to be conducted in terms of Section 6011B, I must concede that insofar as applicant 5, she is facing Schedule 1 charges. Thus, insofar as applicant 5, the onus would then rest on the state to satisfy the court that the interest of justice does not permit her release on bail. Section 60, subsection 4 of the Criminal Procedure Act 51 of 1977 provides, amongst others, that the interests of justice do not permit the release from detention of accused where one or more of the following factors are established. Once again, I wish to emphasize where one or more. That does not mean all those factors must be established. One, if one of those factors has been established, then the interest of justice do not permit. Your Worship, I do not intend going through the various A, B, C, D, and E. Many of my learned friends have already touched and quoted the said factors. Once again, Your Worship, the interest of justice do not permit the release of the applicants where one or more, and not necessarily all, of these grounds are established. Section 60, subsection 5 to subsection 9 provides guidelines or grounds for consideration of the court in determining if any one of those factors have been established. Your Worship, all applicants did not testify but submitted affidavits in support of their applications. The state, on the other hand, tendered viva voce evidence of the investigating officer, Colonel Tieho Jobo Flyman. The court is thus faced with a viva voce evidence adduced by the state, which was subjected to extensive cross-examination on the one hand, and the affidavits, evidence by way of affidavits by the applicants, which could not be tested by way of cross-examination on the other hand. In this regard, Your Worship, I wish to refer the Honorable Court to the same case that has been quoted by Mr. Bota here. That is Matebula versus the State, 2010, Volume 1, SACR, page 55, and it's a Supreme Court of Appeal judgment, where at paragraph 11, the court states as follows, with regard to the case that the court was busy with, and I quote, "In the present instance, the appellant's tilt at the state's case was blunted in several respects. First, he found that the attempt upon affidavit evidence not open to test by cross-examination and therefore less persuasive," unquote. I further wish to refer the Honorable Court to the case of Shabangu versus the State. It's a 2014 case, ZAGPPHC at 832, where the court looked at what was decided in a previous case, and specifically the court analyzed the decision of State versus Book, as in B-O-E-C-K. It's a 2000, Volume 2, SACR 185, where at paragraph H it was stated, and I quote, "If the state elects to use unsatisfactory procedure to adduce evidence in a bail application other than viva voce evidence, they do so at their own peril because value attached to a written statement is clearly less than evidence under oath that can be tested by cross-examination," unquote. Then, having referred to that paragraph in the Book matter, the case in Shabangu, the matter in Shabangu, the Honorable Judge at page 28 then came to the following conclusion, and I quote, "In my view, the same applies to the appellants in this matter. The appellants decided not to testify, but chose to hand in affidavits. They did so at their own peril," unquote. Your Worship, in their addresses and submission to this court, the legal representatives of the appellants are referring this Honorable Court to Section 35(1)(f) and (h) of the Constitution of the Republic of South Africa with regard to the constitutional right of applicants to freedom and right to be presumed innocent until proven guilty. What I do not hear from any of the legal representatives is the limitation clause that is provided for in the same constitution at section 36 of the very same constitution. And Your Worship, the limitation clause in relation to the freedom of the right to freedom and the right to be proven innocent until proven guilty was confirmed in the same constitutional court judgment that has been repeatedly referred to by my learned friends, and that would be the case of State versus Damini, State versus Dadla, and others, State versus Joubert, State versus Shitekat. It's a 1999, Volume 2, SACR 51, and that is the Constitutional Court judgment, where the court even there emphasized, reiterated the limitation of this honorable the rights. Worship, when one look at the affidavits, which are purported to be evidence showing the interest of justice, what all the applicants purported to do in the affidavits is to express and give to this court the personal circumstances regarding each one of them, including their emotional and family ties, the assets, and the like. And my submission is, these were in relation to section 60, subsection 4B, read with section 60, subsection 6, that they will not evade trial. Your Worship, I submit with respect that even in this regard, the applicants did not attentively address most of the relevant factors as per section 60, subsection 6, more so with regard to the following: the extent, if any, to which the accused can afford to forfeit the amount of bail which may be set. I did not hear that. The nature and the gravity of the charge on which the accused is to be tried. None of them in the affidavits mention the gravity thereof, of the charges that are before this honorable court. None of them are saying in their affidavits anything about the strength or weakness or otherwise of the state's case. We hear that for the first time now as they address the court in conclusion to say, oh, the state's case is weak. None of them has adduced any evidence to this effect. And the nature...
Except applicant number 5, who mentioned...
Yes, as it pleases. My apology to Mr. Buata.
Thank you.
Thank you, my brother. And the gravity of the punishment which is likely to be imposed. And they did not adduce any evidence regarding the binding effect and the enforceability of the bail condition. Safe to say, we will abide by any condition that this court sets. Your Worship, when one look at the individual affidavits, factors that the applicants mention as being factors which, according to them, are in the interest of justice for their release can be summed up as follows. At paragraph 39 to 42, applicant number 1 refers to the inability to pursue the labor dispute with his previous employer and the inability to provide for his dependents. That's all that they said in terms of these are what I consider to be in the interest of justice. At paragraph 10.1 and 10.2, applicant number 2 refers to the inability to communicate with his family and the insufficient blankets at Sasolburg prison. These are the factors which, according to the affidavits, are factors which are in the interest of justice that he be released on bail. At paragraph 7, applicant 3 states he is suffering from uncontrollable diabetes and his condition will be best treated outside and that he would like to go back to work. This despite conceding, even now in his address, Mr. Kwenane says he's on suspension, he wants to go back. How do you go back to work when you are under suspension? Suspension means don't come to work. At paragraph 39 to 41, applicant number 4 states same reasons as applicant number 1. And of course, the affidavits of applicant number 1 and applicant number 4, I guess is because they are represented by the same legal rep. They basically are the same from A to Z, except the differences here and there. And I accept that. Then applicant number 5 at paragraph 19 states that she needs to go back to work to provide for her children and buy Gaga dance tickets for the children. But we hear she has lost her employment, and yet she wants to go back to work as per the affidavit. Bishop, I submit with respect that these factors cannot satisfy the court that the interest of justice permits their release on bail. None of the applicants substantiated or proved on a balance of probabilities any of those factors. Furthermore, Your Worship, I wish to point out the following with regard to the affidavits that are before court, which I regard as evidence. Applicant 1 and 4, as I indicated, are represented by the same legal representative. They coincidentally both are doing odd jobs and gambling. But the nature of the odd jobs and the gambling, there can be many gambling, there can be many odd jobs, many. The nature of this has not been revealed to this honorable court. The income has not been revealed, safe to say what I get out of odd job and gambling is enough to cover the household necessities. Applicant 1 and 4, despite disclosing their passports and surrendering them to the investigating officer, which we are appreciative to Mr. Mururi for having surrendered the passport in an open court. We quite appreciate that. However, both of them, in their affidavits, do not reveal and do not disclose to this court that they have been traveling to Lesotho, which is one of the factors that one should be considering. They disclose they do have passports, granted, fair, and like I said, good enough. But they do not say, we have been using these passports to travel to Lesotho on this and that and that. We only learned when Mr. Mururi was cross-examining the investigating officer that applicant 1 went to Lesotho basically for the first time, accompanying the then girlfriend to the tombstones. And on other occasions, it was, of course, for cultural purposes and all that. And despite having the passports openly displayed in this honorable court and being surrendered, still we do not get any revelation from the applicant number 4 about the traveling to Lesotho. It was only when the state re-examined that I then asked the investigating officer if after the surrendering he perused it and then he mentioned the traveling to Lesotho. The question is, why would you not be open to this court and reveal to this court that I have been traveling outside this country? Why would you do that if you are saying you have no intention of evading your trial? Why would you do that? Your Worship, furthermore, the investigating officer testified that applicant 1 registered one of his properties, which is a vehicle, at an address which is not the domicilium sitandi et executandi. That is his address of abode, usual abode, where service of whatever document must be. You know, and yet he mentioned the car in the affidavit and said the public out there, someone, it has been reported about the buying of the car, but yes, I do have a car. But now they do not disclose this other address to this honorable court in their own affidavits. It's now that when my learned friend addresses the courts, that he says he has disclosed to this court an alternative address. It's not in the affidavit. It is only when the investigating officer testified that through cross-examination, my learned friend conceded that it is indeed an address of a family member of applicant number 1. Why have you not been telling this honorable court about this address? If this court has to believe you when you say you have no intention of evading your trial. And why, even now, even in his own address, the legal representative, when the opportunity arose, and when the opportunity arose to cross-examine the investigating officer, no explanation was given about this address. And yet, we hear that we have no intention of evading our trial. Yes. Applicant 2, in his own affidavit, he failed to disclose the fact that he is in a business of buying and selling cattle. He did not disclose that. He failed to dispute the evidence. That was the evidence that comes with the IO. And now when the legal representative of applicant number 2 is, the court engages him in terms of, if you say your client does not have money, blah, 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 but yet you suggest 5,000 rand, then we hear, no. Remember, we have a business of buying and selling cattle, and we have already sold 1 now. We are left with 2. We don't have this evidence on record. And I want to point out that submission in the in conclusion of a hearing, submissions are not evidence. I've heard a lot of submissions purported to be evidence. Those are not evidence. Evidence, and correctly at some stage the court questioned, I can't remember who that, but I don't have that evidence. It's only what you are telling me now. And the court was quite correct. And just on that aspect again, applicant number 2, we heard from the investigating officer that he took out a bank account in a different address. Was it 2? In a different address other than the address where he stays. We don't have an explanation for that. Why? If you know this is the place where whoever wants me will get me here. And yet, for the purpose of a bank account, you give a different address. For purpose of a car, you give a different address. Why would one want to do that? If indeed it's because you don't want to be found there where you stay. Similarly, can the court really say, I am satisfied with the evidence before me? Granted. The investigating officer, and it is not his duty to do so, same way as I agree with my learned friend, Mr. Magamedi, that it is not for the NPA to say I'm satisfied with what. It is also not for the investigating officer to conclude and say, yes, they will not evade trial. It is for this court, having listened to all the evidence before it, that this court can say the evidence and the factors that I have considered, indeed, there is no likelihood of any of the applicants evading their trial. Having assessed the evidence, it's not for the investigating officer, oh yes, they will. That's why he kept on responding, but that I do not know. I do not know what is his intention. I do not know if he, yes, indeed. All that he put before this court is the personal circumstances and revealed some of the factors which the applicant themselves did not disclose to this honorable court. Applicant number 3. I want to submit with respect that with regard to ownership of the house, he lied under oath. I must put it blankly. It is not true. He said in his affidavit, that is my house. The investigating officer comes and testifies under oath, and he gets cross-examined. That says, that is not his house. It is the house of his in-laws. And when Mr. Konani, the court having adjourned, I suppose, he took further instructions. He came back and said, yes, it is the house belonging to the grandmother of the wife of applicant number 3. And then he questioned or suggested to the investigating officer the fact that applicant and his wife are married in community of property, thus wanting to give the impression that because they are married in community of property, therefore that house belongs to applicant. But that cannot be true, because he says it belongs to the grandmother of his wife. The property of a grandmother or a grandfather of your in-laws cannot by means be part of your community of property. The question is, why in the first place he did not say in his affidavit, I stay at house number so and so, I have been staying for so many years, I stay with my wife, and that house belongs to my wife's grandmother. Why would you not say so in your affidavit and yet go and say it is my house, when in fact now we know it is not true, it is not his house? That to me is an untruth factor that has been mentioned before this court. Your Worship, having dealt with the affidavits so far, and I wish to now move to the evidence that was adduced viva voce by the investigating officer. My apology. Joseph, the investigating officer adduced viva voce evidence outlining firstly how the crime was committed, and secondly how each of the applicant is linked, and lastly, as correctly pointed out, given reasons why he is opposed to the release of the applicants on bail. Joseph, I submit with respect that he was a very credible witness. The four legal representatives cross-examined him extensively, but could not crack him. He conceded where he made mistakes. And what does this show? It shows credibility. He's credible. He concedes, no, I made a mistake. Yes, I agree with you. But he stood his ground in terms of the factors that are known to him as the investigating officer. He remained calm, he was firm, and he was confident in the witness stand. He was confident, firm. Despite the fact that I think the cross-examination took place over 2 days or so. He was firm. And he became emotional when he needed to become emotional. And after 5 minutes after the court granted him that 5 minutes to Dangas, he came back, he went on, testified, like I said, very confident, and that's it. Joseph, insofar as section 60, subsection 4b, the investigating officer considered there's no proof, like I said, that the applicants are flight risk. Indeed. But I'm saying that is not his job to say they are flight risk. He just placed before this honorable court factors that are known to him, and at the end of the day, like I said, the court must assess and look at the factors, look at the evidence, and look at whether indeed the interest of justice permits the release of the accused or not. And that is once again talks to the credibility of the investigating officer. He says, I don't have, but I don't know. When they ask, do you have evidence they will commit Schedule 1 offenses when released on bail? He says, I don't know. All that I know is that they have now been before court for having committed crime. And that's it. We can't falter him. The court must assess that evidence. Yes, Section 60, subsection 6, lists a number of factors that the court must consider whether the ground in Section 64B has been established. One of which, just refer to one of which is the strength of the case against the accused and the incentive that the applicants may, in consequence, have to attempt to evade trial. Let me refer this honorable court to the SCA judgment of State versus Koch, as in K-O-C-K. It's a 2003, volume 2, SACR 5. Like I said, SCA. At paragraph 11, the court stated as follows, and I quote, the strength or weaknesses of the state's case must be given consideration in determining where the interests of justice lie for purpose of section 60, 11B. The court held that the state has either failed to make a case or has relied on one which is so lacking in detail and persuasion that a court hearing a bail application cannot express even a prima facie view as to its strength or weaknesses, then the accused must be given the benefit of the doubt. The court went on to conclude, and I quote, failure by the magistrate to pay attention to this important factor in the evaluation of the application constitutes misdirection on her part, unquote. So the court must consider the strength of the state's case. Like I indicated earlier, the applicants did not attempt to challenge the strength of the state's case. What we have before this court now on record is the assertion or the statements put to the investigating officer. Remember, we don't have evidence from the applicants that says the state's case is weak or is tainted or what. We don't have. The investigating officer come and outline what a case is and how each one of the accused are linked. Then what we have on record is that at the right time, at the right forum, the accused will tell the court, firstly, about the transaction of the monies in respect of applicant 1 and the like. At the right time, at the right forum. That is what we have been hearing insofar as what the case is against each one of the accused. Which is the right time and the right forum to determine the strength of the state's case other than this court now, knowing prima facie evaluation, the strength of the state's case. It's one of the factors that the court need to consider, the strength of the state's case. And that is my submission, Your Worship. At least through cross-examination, show this court that no, the state's case is weak. We have evidence from the investigating officer saying there is pointing out, there is confession in brackets, is the nature of the evidence that the state has. We're not here dealing with the admissibility or otherwise of that pointing out or confession. The trial court will deal with that. But we are saying, the investigating officer is saying, this is what I have to show the strength of the state's case. Then we will deal with that at the right time, at the right forum. And I'm saying, this is the right time and the right forum for the consideration of whether it is in the interest of justice that the appellants be released on bail. And I must add to say, other than the fact that there is no evidence, like I said, we hear some of the things when my learned friends are addressing. In their closing argument, they now raise the issue that the state's case is weak. We now hear, for instance, applicant number 5 saying, well, it's very weak. The evidence is this. But the fact of the matter is the evidence is both her and appellant number 4 opened the gate for Mr. Bester to pass. Whether she was on duty, doing her job, that is for the trial court, but that is the nature of evidence that the state has now. Yes. Let me refer the court to one of the cases that the court was referred to, and that was State versus Jonas, 1998, Volume 2, SACR 677 SCA, where the court held that to be successful, the applicant had to show by adducing acceptable evidence that the state's case against him is non-existent or subject to serious doubt. This we hear from the heads of arguments. Nothing has been adduced in the form of an acceptable evidence before this honorable court. Remember, Your Worship, once again let me remind the court that the duty is not on the state to show that it is in the interest of the applicants that they be denied bail. The duty is on them. The burden is on them to adduce evidence before this honorable court that it is in the interest of justice that they be released on bail. Now, the submissions by my learned friends is more attacking what the investigating officer testified about, as if it was actually the state's burden to prove something here. That the investigating officer said this and that, it was not truthful. It was not for the state to adduce evidence to satisfy this court that it is in the interest of justice that they done this. Insofar as Section 64C, I'm moving on. The investigating officer testified that the witnesses in this matter already testified in the disciplinary hearing of some of the applicants and thus known to the applicants. He testified that all these witnesses are colleagues of the applicants. The fact that these witnesses testified in the hearing that resulted in a dismissal of some of the applicants, to my submission, tend to prove that the applicants are aware of the witnesses and the nature of testimony they are likely to give during trial. And then let me move on to Section 60, subsection 4D. It is the testimony, of the investigating officer that if released on bail, the applicants will undermine or jeopardize the objective of the criminal justice system, including the bail system. In this regard, Your Worship, in substantiating why he referred to this honorable court to the manner in which this offense took place, and he sort of also at the same time touched on 60 subsection 4E, which I wish to take to address the court at the same time, both 64 D, and E. But before then, Your Worship, let me rather leave it. I've already dealt with it. The investigating officer testified about the likelihood that the release of the applicants will have in disturbing the public order and the undermining of the public peace and security. He testified that the nature of the offense and the manner it was orchestrated induced shock and outrage in the community and the public at large. And he sort of substantiated by saying, this case has attracted huge public interest, both locally and internationally. And while he was testifying, he turned around in response to one of the questions and said, look at the media, the number of the media house in this court here today, to substantiate the interest, the kind of interest that this case has generated. And I want to submit with respect that that was one of the considerations when the court ordered, it's on record, that the publication or the broadcast of this case should be live. The court considered the nature of the interest that the public out there has in this case. He testified about the fact that there was a special parliamentary session, not to dictate to this court, I'm sorry, but he was saying the kind of interest that this case has out there, that it shocked, that it caused outrage, even to the members of parliament that says, South African Police Services, Department of Correctional Services, G4S, come and account to the members of the public out there about this case. He was just substantiating why he says that it has caused and induced a sense of shock in the community. And he goes on to say, the sense of shock is as a result of the following. A person who has been convicted of rape and murder, sentenced to life, is sent to prison. And that person, who according to him, in his testimony, is a dangerous person, is assisted to escape. That is the first part. And he says, in that regard, the victims of the cases that resulted in him being in prison were at risk because of his escape. That is testimony. That was never attacked. That was never challenged. It is his testimony. And he says not only those victims, even the entire public's life was at risk because this is a danger. He's a danger. Hence he is in prison because he's a danger. He's taken away from the community because he's a dangerous person. He's taken to prison and be guarded by who? Some of the appellants before this court. Assisted to escape by who? The very same appellants that are before this court. And that outraged the community. That is his evidence. As a please the court. And then he went on to say, to outline to this court what the case is about. And I need to re-emphasize, I need not repeat his evidence, but I'm saying, Yoshi, in this instance, we have evidence. He says we have evidence. The case is that applicant number 1 drives into prison with a buggy, which was hired at OR Tambo, of course by accused number 2. And then in the back of the buggy, we have a TV stand, and behind that TV stand, or underneath, there's a corpse. The corpse of a person who was at a taxi rank, then for whatever reason that we don't know here, he collapsed there, taken to a hospital, and he died. One of the accused, by the name of Nandipa, comes and claims this body. That is now for trial. But the fact of the matter is, that body ends up in prison. The next of kin, and that I think is what made the investigating officer emotional. The next of kin are supposed now to bury their loved one, decently, and the next of kin does not know. They do not know. They get this in the news, I think, now in March, as he testified that, at prison there was a corpse that was smuggled into corpse, and that. Unbeknown to them, that this is their loved ones. And then the corpse is smuggled into prison, into a workshop, stays there overnight, then is taken in a wheelie dustbin into a dark room, and then is taken out of the dark room into cell 35. What happens next? That cell is set alight. The corpse that we know by now is Katlego Bereng, is set alight. The poor next of kin, they do not know. And when this news, he says, when this news came out in March this year, it caused an outrage in the community, understandably so. So he is saying to this court that the manner in which how this happened, and what angered the community, he says, is the fact that it involves the people who were supposed to make sure that this person stays behind bar for life. They are the ones that are found to have been involved in the escape of the person we now know is Thabo Bester. By the way, I see he's got an ID, but he's Thabo Bester. Only to find that it's actually Katlego Bereng. And this, he says, it caused an outrage. And now the police have arrested the people, and he says, if this court then released them, having regard to these circumstances, that release will undermine the confidence that the community has in this court, will undermine the confidence that the community has in the South African police services. Hence, he says the community will say, SAPS has not done their job. It is the confidence that the SAPS has, the community has in the South African police services. And he comes and testifies and says, all this happened the community is life. The members of the community are placed in life, in danger. The victim of the crimes involving Thabo Bester are put in danger. For what? At the end of the day, for 150,000 rands. There was a promise of 2.5 million. I don't want to get there, but he says at the end of the day, it was for money. That's where the community outrage aspect in his evidence comes in. And it is the breach of the security protocol at G4S. Applicant 2 tampered with the system to facilitate the entry of the corpse and the escape of accused number 5, who happens to be Thabo Bester. That is the essence of his evidence. That he says, we have evidence, we have statements that we will present at trial. Applicant 4 and 5, he says, who were on duty in the central control room, CCR, disconnected the cameras and opened the gates, thus enabling accused number 5 to escape. And he then goes on to say, to testify, which is undisputed in any way, that the deceased, who we now know as Katlego Bereng, was a staunch member of the Bloemfontein Celtic Supporters Club, and this explains why there is demonstration and picketing outside the court on the days that he mentioned and at Katlego's funeral. Because it is a member of a Bloemfontein Celtic Supporters Club, which, by the way, my learned friends then questioned that in respect of two aspects. Question the fact that Bloemfontein Celtic Football Club does not exist. It's not about Bloemfontein Celtic Football Club. It's about Bloemfontein Celtic Supporters Club, which the IO went on when he was questioned about the existence or non-existence of the football club. He says the Supporters Club is still there. And let me tell you, they even now give that support of theirs as Bloemfontein Celtic Football Club to Marumo Gallants. That is his evidence. So that Bloemfontein Celtic Supporters Football Supporters Club is in existence and is lively because they are doing picketing, and they even spoke at the funeral of the Bereng. What does this demonstrate? It demonstrates that the community out there has been angered by this. And that cannot be disputed. The fact that there were 50 people, the number to me, Your Worship, with most respect, the demonstration, the picketing itself could not be disputed. That there were 10 people or 20, it shows that we are enough. How many in terms of numbers? How many people do have to express their outrage to a commission of crime? Do they have to be 10,000? As it was suggested that normally when Bloemfontein Celtic used to play, there used to be 10,000 supporters. Do they have any kind of demonstration, irrespective of the number? It's an outrage. It's a demonstration that we are having enough of this crime. That to me is very crucial, and not the number. Yes, the duty of the courts in matters such as this one was laid down in the matter of Shitekat, 1999, 1 SACR 100 and is a Cape decision, where the court at paragraph 104, paragraph H, stated the following, and I quote, "It is true to say it is the duty of the courts of law to ensure maintenance of law, order, and justice, and so prevent that the greatest of all evils, a criminal justice system so weak and vacillating that people feel the need to avoid the courts and take the law into their own hands," unquote. The testimony of the investigating officer. This was already decided in this case. The courts have a greater obligation to society at large. They must jealously guard the rule of law, that it is the lesson of this country. Unquote. I omitted to mention to the court that I'm proceeding with the quote. I'm sorry. And this is exactly the evidence of Colonel Flyman. And here the court says we must guard against those lessons that this country has learned. Colonel Flyman and says, I'm saying to this court, it is your responsibilities, it is your obligation to preserve and to make sure there's maintenance of law and order and justice, and that the rule of law prevails. And he says, I want to make reference to this court to what happened in KZN and Sienega. And he actually wanted to say this court, we as a country, we have learned our lessons out of that. Hence he brought in to say there was violence in those two places that he has mentioned. That's how it comes in. Not necessarily for the state then to lead evidence exactly what happened, who did what in KZN. He says there was a violence and uprising as a result of a certain factor. And he says to this court, based on this case law, of the obligation that this court has, the court has to that obligation. And I submit in conclusion, Your Worship, that the state, the evidence of the investigating officer has established that the shock and outrage of the community at large might lead to public disorder. Secondly, that the safety of the applicants might be jeopardized, and that the release of the applicants on bail will undermine and jeopardize the public confidence in the criminal justice system. And that is the essence of the evidence of Colonel Fly. And yes, Section 64E says in exceptional circumstances, the court must consider that. There has been cases where bail was denied on the basis of Section 64E. And one of those is State versus Miselo, M-I-S-E-L-O, the 2002 one, SACR 49, once again the Cape Division decision. It's an example where the court considered Section 64E and denied bail. And at paragraph 23, the court held as follows, and I quote, in my view, the release of the appellants on bail will undermine the public confidence in the criminal justice system, unquote. And this, like I said, is exactly the testimony of Colonel Flyman. In conclusion, I think the second time that I say in conclusion, the state respectfully submit that the appellants 1 to 4 failed to discharge the onus to prove or to satisfy this honorable court on a balance of probabilities that the interest of justice permits their release on bail. And insofar as applicant number 5, reverse onus, it is my respectful submission that the state managed to place evidence before this court satisfying, adducing evidence that should satisfy this court that it is in the interest of justice that she, together with the rest of the appellants, be kept in custody pending the finalization of this matter, and that the release of appellant number 5, applicant 5 on bail is not in the interest of justice. That is the conclusion of my address, Your Worship.
Mr. Matoko, before you sit down, I omitted also to take it up with Mr. Kwenani, but I think I will invite him in this regard, perhaps other attorneys, on one aspect. The provisions of section 60, subsection 4, paragraph E. Is it applicable in Schedule 5 or Schedule 6? Or will you argue to say it is applicable in both?
Yes, my submission is applicable in both. And I think the court should not be, I think the court asks that question on the basis of the wording. Because it starts by saying,
No.
in exceptional.
Yeah, the court is not asking it because of the wording, but
Yes,
like
yes.
I said, I'm tempted to ask it because I wanted to take it up with Mr. Kwenani, because when he was addressing me, he made a reference to the fact that Schedule 60, Section 60, subsection 4, paragraph E, deals with exceptional circumstances. Then I foresaw perhaps what he intended to say, but I omitted to take it up with him. So I want to be addressed
Your Worship,
so that we be on the same page.
Section 60, subsection 4A to E, it is my submission, is applicable to both Schedule 5 and Schedule 6.
Thank you. Yes, without much ado, I
Thank
just
you.
want to...
Thank you.
Mr. Murori, before I take Mr. Kwenani, let me come up with you. Just on the Section 60, subsection 4, paragraph E.
Your Worship, and I accept where the question is coming from, Your Worship. I cannot responsibly make a submission in this instance. But I would say, I will take guidance from my learned colleagues, but even better, Your Worship, I could reserve that aspect, and I will address you when I get the opportunity to make my closing remarks, given the response by the state. And if I could just park that bus right here, and I'll address you later, Your Worship.
Thank you.
Mr. Court, please.
Mr. Makamedi, do you want to say anything at this stage with regard to Section 60, subsection 4, paragraph E?
Yes, Your Worship. It's my submission that if Section 64A to A has been read into context, it clearly indicates that it applies in both Schedule 5 and Schedule 6, and that's something that we dealt extensively with.
Thank you. Mr. Kwenani?
Your Worship, I would like to do justice to that aspect. And with all respect, both to the court and my learned colleagues that are here, I do not want to be known for approaching such an important thing through a method that I call a shotgun approach. I can answer the court now, but the answer needs to be substantial because it's a very important aspect which would have a bearing on the liberty, particularly of accused number 6. I am going to answer the court if I could propose to this honorable court that, because we still need to respond to the issues pertaining to, yes, indeed, the affidavits in particular, because that matter we've never dealt with. If if the court agrees, I would address the court tomorrow.
Mr. Gota?
Section 64 E, Your Worship, is both applicable, Schedule 5 and Schedule 6. That is my opinion. As it please the court.
Mr. Makambo, let me get back to you. For applicant number 1, 2, 3, and 4, in fact, for the applicants, all of the applicants, it is submitted that the state case is weak. State case is porous. Just in short, what is your reaction on that?
Your Worship, I've already addressed the court on the strength of the state case and the fact that they have not, none of them, adduced evidence to say the state case is weak. None of them. Even in cross-examination, they did not attack the strength of the state case at all.
There is evidence that I also will not ignore. Because one would remember that the court is the upper guardian of the minor children. I am told through the affidavits, exhibits before me, that the applicants do have minor children. And this will seek the court also to consider the provisions of Section 28 of the Constitution, which indicates that the interest of the minor children are of paramount importance. Any comment with regard to that?
Your Worship, I hear what I was just wanting to confirm with my learned friend about the case law. I think it's Teddy Bear or whatever, that also dealt with that aspect. In this instance, Your Worship, all the applicants, except for applicant number 5, are saying they are joint guardians. All of them, they have in their affidavit say they are married, they stay with their mothers, and the like. Applicant number 5 says there's a grandmother. She herself, applicant, stays at a back room, but there's a grandmother who I want to believe is even taking care of the children now. So it's not that they are the sole guardians. No, all of them in their affidavits have disclosed that they do have partners and that they have mothers, except for the one applicant who said, I can't remember who it was, but the children are staying with the mother and he is staying alone. So that can be applicable. Yes, the court is the upper guardian, but in this instance, there are the mothers in respect of 1, 2, 3, and 4 who can take charge and care of those children.
In other words, you submit to say there is no evidence that tends to suggest that they are primary caregiver.
That's the way that I was trying to look at. They are not. Yes, there's no such evidence. I agree.
Mr. Bernard?
I'm just worried, Your Worship, whether are we going to be given a chance to deal with this, or is it...
Yes, as per application. You will...
Can I just then suggest, Your Worship, with respect, that they are...
Procedurally, if you want to respond or to react, because I would have afforded each one of you an opportunity to address. And then if you wish to respond, then you will apply, indicate to me. I will listen to you, should needs arise.
With respect, Your Worship, if I may, there are aspects, I don't know unless the court is going to make a ruling with regard to what I regard as new information pertaining to some aspects of affidavits, which I think we should actually respond to, Your Worship. I'm not sure whether it's...
Yes, you will be afforded an opportunity, Mr. Kwana, and I'm not going to make a ruling now or today. I will hear from you.
Okay. God bless us, Your Worship. I would then also like to deal with other aspects when the right time comes. God bless you.
Thank you.
Just before they speak, unfortunately, this water of mine is finished now. It would appear that there's a nature calling as a matter of urgency somewhere. Just 2 or 3 minutes, or I can even give my learned friend can take over, but I need to rush.
I think let's adjourn for
Yes,
5
yes,
minutes quickly. Okay, thank you. Adjourns?
Kenya miti ya ukamu.
5 minutes.
Kenya miti ya ukamu. Sela miti ya ukamu man.
Yeah, but in case I saw
Looks like we need to arrange a date somehow. There's absolutely no way that you are going to respond today. I think. Am I right? You said you want to arrange a date. No, are you going to arrange now for respond to? Well, okay. I see that everybody is ignoring me.
fine, Your Worship. I'll push as hard as possible.
That's fine with me, and I suppose with everybody.
9 o'clock tomorrow.
We will accept 9 o'clock, it's reasonable. We will be here. Court pleases.
Thank you.
Confirm 9.
Thank you. You may rise up, gentlemen in the lady. Case is remanded until tomorrow, the 24th day of May 2023, same court number 20A, for further address on bail application before judgment. All of you, you will remain in custody until then.
My apologies, Your Worship. I do not mean to speak once you have made your pronouncement. I think my learned colleague brought a very important aspect. Given that we need to start timeously tomorrow, Your Worship, and I'm not being presumptuous in any way, some of the accused persons are kept at centers that are very far from Bloemfontein. I think it would only be proper if an arrangement were to be made, and my colleague has indicated that he intends to make an arrangement, and we just perhaps place it on record that they be kept locally, where they can reach here before 9 o'clock.
Yeah, it is the prerogative of the state to make such arrangements and engagements.
Oh.
But if state agrees that it be rolled over until tomorrow, then certainly there is no problem.
Yes, the court pleases, Your Worship. Thank you. And we are indebted to you.
Thank you. Until tomorrow in the morning. Thank you. Court adjourns.
With your client, because they don't have facilities anywhere in